Bon matin, good morning. I will begin today with the University of Ottawa's Indigenous Affirmation. Puisque nous commençons cet événement à partir d'Ottawa, nous rendons hommage au peuple algonquin, gardien traditionnel de cette terre. Nous reconnaissons le lien sacré de longue date l'unissant à ce territoire qui demeure non cédé. We pay respect to all Indigenous people in this region, from all nations across Canada, who call Ottawa home. We acknowledge the traditional knowledge keepers, both young and old, and we honor their courageous leaders, past, present, and future. Good morning and welcome to all. And in particular, I'd like to give a special welcome to Senator Peter Harder, who's with us here in Ottawa. And I believe there are some senators also joining online. And a special welcome also to Maître Jacques Frémont, le recteur et vice-chancelier de l'Université d'Ottawa, who I believe is also online. Welcome all. My name is Marion Sandilands. I'm a lawyer at Conway Litigation and a part-time professor at the University of Ottawa. I'm also a board member of the International Commission of Jurists Canada, one of the organizers of today's event. ICJ Canada is a civil society organization that supports human rights, the rule of law, and the independence of the judiciary. And it's my great pleasure to kick off this exciting day. So what are we doing here today? In case there was any remaining doubt, we now live in interesting times. I was asked to give an overview of what's been happening with Section 33 lately in 10 minutes or less. I said, no problem. I'm not an academic, I'm a practitioner. And as a lawyer called to the bar in Ontario, I have taken an oath to, quote, champion the rule of law and safeguard the rights and freedoms of all persons, unquote. It is in that capacity that I make my comments today. Quelques notions de base sur l'article 33. L'article 33 de la Charte permet au législateur de déclarer qu'une loi a effet indépendamment de certains droits garantis par la Charte, à savoir les libertés fondamentales, les garanties juridiques et les droits à l'égalité. Elle est le fruit d'un compromis célèbre. Sans l'article 33, la Charte n'existerait pas. Elle expire automatiquement au bout de 5 ans et doit être renouvelée, ce qui permet à l'électorat de se prononcer dans les urnes. Après quelques années tumultueuses d'utilisation dans les années 80, principalement par le Québec, l'article 33 a été mis au sommet. La plupart des théoriciens pensaient qu'il serait politiquement trop impopulaire pour être touché. Well, since 2018, the clause has seen a dramatic and paradigm-shifting revival. In 2018, Saskatchewan invoked Section 33 to maintain the status quo, essentially, while a constitutional challenge to school funding legislation worked its way through the courts. Not 3 months later, Ontario, which had never before invoked the clause, considered it in connection with the Toronto City elections, before a decision by the Court of Appeal for Ontario rendered that unnecessary. Ontario then twice resorted to Section 33, first in election financing legislation in 2021, and next in an abortive attempt to forestall education strikes in 2022. Switch to Quebec. In 2019, Quebec began its own distinct revival. For the first time in its history, Quebec derogated in the broadest possible manner, preemptively, from both the Canadian Charter and the Quebec Charter of Human Rights and Freedoms in the Laicity Bill, Bill 21. And Quebec repeated this pattern in 2021 in an omnibus language bill, and then renewed the clause just this year over Bill 21 at the 5-year mark. In 2023, Saskatchewan returned to the Notwithstanding Clause in a law prohibiting educators from referring to children by their chosen pronouns without parental consent. Now, from this dizzying list, there are 3 major court challenges either before the Supreme Court or on their way there. First, there's the Ontario challenge to the election financing bill, which has already been heard at the Supreme Court. From Quebec, there's Bill 21. We're waiting for a decision on leave from the Supreme Court. And in Saskatchewan, the pronouns case is right now before the Saskatchewan Court of Appeal. Now, that brings us to this fall. While we wait for the Supreme Court to decide whether it will hear the Bill 21 appeal, Section 33 keeps on trucking. At the end of October, The Premier of Ontario suggested that Section 33 should be used to clear homeless encampments, and 13 mayors asked the Premier to do just that. The very next week, the Premier of Quebec suggested that Section 33 could help with Quebec's doctor shortage by forcing doctors to remain in the province's public system. I forgot to write this in my speech, but I should also mention that the leader of the opposition several months ago floated the idea of using Section 33 in criminal and bail contexts. Now, these two recent mentions by Quebec and Ontario are quite interesting for a rhetorical turn. Apparently, Section 33 is now the answer to every intractable policy problem. Never mind if it won't actually fix the problem. Invoking the Notwithstanding Clause is a signal that you're really serious about the problem. Now, another point I'd like to make is that these latest mentions this month would have been inconceivable 5 years ago. But now it seems to be politics as usual, and this is in Canada's two most populous provinces. And here's yet another one just this week. The Comité consultatif sur les enjeux constitutionnels du Québec au sein de la Fédération canadienne released its report. Now, for those of you not following, this committee was struck by Quebec's Minister of Justice several months ago, and it's a serious report. And the report contains 44 recommendations for constitutional reforms to increase Quebec's autonomy as a federated state. And recommendation number 10 is to invoke Section 33 preemptively over Quebec's entire statute book. I didn't make this up. Cela aurait également été inconcevable il y a 5 ans. Nous pouvons et devons avoir des débats sains sur ce qui se passe, sur les raisons pour lesquelles certaines législatures ont invoqué la clause, sur les raisons fondées ou non sur les principes. Par exemple, cette résurgence est-elle une réponse à des interprétations judiciaires trop larges des droits? Certaines législatures utilisent-elles l'article 33 pour protéger les droits non prévus par la Charte ou protéger les intérêts collectifs? Les raisons peuvent être complexes, elles peuvent être multiples. Nous pouvons être en désaccord. Mais une chose est sûre, la scène a totalement changé. En quelques années, l'article 33 est passé d'un tabou à un réflexe. And I'd like to ask 2 questions. Why now? And who benefits? I would suggest that what we're seeing with Section 33 is not a cause, but rather a symptom of some even bigger changes in political culture. But I only have 10 minutes. Now, I'm a litigator, and I prefer to talk to courts. And I've come to the view, however, that if there's a problem here, the courts aren't going to be the ones to fix it. Section 33 relies on and demands what Peter Russell calls a, quote, active citizenry to be the guardians of liberty. Section 33 means that the buck stops not with the courts, but with us as citizens. It's a unique feature of our charter, and it's one I think it's high time that we embraced. Now that brings me to the origin story for this event. This event is called a call to action, fundamental rights and the Notwithstanding Clause. This event began around the ICJ board table as an idea. Many of us were deeply concerned about the resurgence of the Notwithstanding Clause, and in particular, on the erosion of respect for fundamental rights in Canada. Some of us were noticing its use in specific places, Quebec, Ontario, Saskatchewan. But was anyone looking at the whole picture? Like, what was the trend and why is there a trend? Then it developed into a crazier idea. Why don't we join up partners in multiple cities across Canada? Let's have a truly national conversation in both official languages. Let's talk to one another. C'est ainsi que cet événement a vu le jour, grâce au leadership de la CIG Canada et au véritable partenariat de 4 centres dans 3 villes. À Ottawa, l'Institut de développement professionnel de l'Université d'Ottawa et le Centre de droit public de l'Université d'Ottawa, avec la coordination du professeur Errol Mendez, président de la CIG Canada, et Slava Balan, directeur général de la CIG Canada. À Montréal, la faculté de droit de l'Université de Montréal, avec la coordination du professeur Stéphane Beaulac, membre du conseil d'administration de la CIG Canada. Et troisièmement, à Edmonton, le Centre d'études constitutionnelles à la faculté de droit de l'Université d'Alberta, avec le leadership de Richard Maley, directeur. Merci à vous tous. Aujourd'hui, il y aura 3 panels, un par centre. Chaque panel aura un élément régional, bien sûr, mais aussi abordera également des questions plus grandes. J'espère que nous apprendrons tous quelque chose, que nous soulèverons de nouvelles questions et que nous nous encourageons les uns les autres. Thank you to all those involved in making today come together. Thank you to all the panelists for giving so generously of your time and expertise, and thank you to our tech magicians at each hub who are making this run. And without further ado, I will turn us over to Montreal for the first panel. Thank you.
Merci, Marion. Bonjour à tous et à toutes. En présentiel, via Zoom. Bonjour aux collègues et participantes d'Ottawa, en particulier Marion, Hérol, Slava. A good morning also to the participants and the collaborators in Edmonton, in particular Richard and Professor Anna Lund. Looking forward to all your presentation. Nous avons la chance à Montréal, après ce bref topo d'introduction, de débuter avec un premier panel. Mon nom est Stéphane Beaulac, je suis professeur titulaire ici à l'Université de Montréal. Mes enseignements portent principalement en droit international public et en droit constitutionnel. À ma gauche, votre droite, la professeure Karine Miller, spécialiste de droit public, droit constitutionnel, droit autochtone notamment. À ma droite, journaliste et chroniqueur à la presse, Vincent Brousseau-Pouliot. Nous allons prendre la parole dans l'ordre. Toutefois, la première présentation conjointe avec ma collègue Karine pour le premier 30 minutes environ, et ensuite Vincent prendra. 1 minute en introduction, toutefois, avant de passer la parole à Karine. Pour débuter peut-être avec une anecdote, mon collègue de chez Dentons, Gilles Rémillard, ancien ministre de la Justice dans le gouvernement de Robert Bourassa à la fin des années 90, et pour la petite histoire, qui a pris le relais après la démission du vieux senior dans le groupe s'en souviendront, a pris le relais, Gilles Rémillard, après la démission de M. Herbert Marx, qui a principalement laissé la politique en réaction à l'utilisation de la clause de dérogation dans le cadre de l'adoption de la loi 178 à l'époque, en matière d'affichage commercial. Alors, Gilles Rémillard a déjà dit de la clause de dérogation de l'article 33 qu'il ne fallait pas se tromper, que c'était quand même pas une décoration. Ça, en droit, suivant la méthodologie d'interprétation législative, ça renvoie au principe de l'effet utile. Le Parlement, le constituant, ne parle pas pour rien dire. Cela dit, certains vont un peu plus loin et utilisent l'image du fusil de Tchekhov, célèbre dramaturge russe. L'idée étant que l'article 33 de la Charte, un peu comme le fusil au début d'une pièce, s'il est là, c'est qu'il faut s'en servir. Sinon, à quoi bon? Le problème, toutefois, avec ces métaphores, c'est qu'elles contribuent, à mon humble avis, à dénaturer le régime supralégislatif de protection des droits humains. Une affaire de charte, ce n'est pas un sapin qu'on décore, qu'on choisit de décorer avec des boules ou des guirlandes. Les droits et libertés de la personne ne sont pas des cadeaux que l'État décide de nous donner si les enfants, si les justiciables sont sages. Non, il faut le rappeler haut et fort, Et on le sait clairement depuis le mouvement en faveur de la protection des droits humains suivant la Seconde Guerre mondiale à l'international. Si on a appris quelque chose, vrai, c'est que l'on parle d'éléments qui sont inhérents et inaliénables de la personne humaine. Dixit, Déclaration universelle des droits de l'homme de 1948. D'où le premier panel qui s'intitule « Retour aux sources ». Comprendre les principes gouvernant la Charte canadienne pour mieux appréhender les possibles dérogations en vertu de la Charte. Alors, après cette introduction, je passe la parole à ma collègue, la professeure Karine Miller.
Merci Stéphane. Bonjour tout le monde. Alors, on est ici ce matin pour parler de ce qu'on appelle la clause dérogatoire dans la Charte canadienne. Moi, je voudrais débuter plutôt en mettant de l'avant le fait que notre charte n'a pas une, mais bien deux clauses dérogatoires aujourd'hui. Depuis l'arrêt Dixon contre la Première Nation Vuntut-Gwitchin, qui a été rendu à la fin du mois de mars dernier, qui est un arrêt dont on a très peu parlé, en tout cas au Québec ou dans l'Est du pays, malgré le fait que c'est un arrêt qui a une portée majeure en droit constitutionnel, et qui porte sur l'article 25 de la Charte. C'est une clause qui permet de déroger aux droits, mais au bénéfice des peuples autochtones. C'est vraiment une clause qui est différente, mais les enseignements de la Cour suprême dans ce contexte contemporain sont très pertinents pour voir comment en 2024, et pas dans les années 80, comme dans le temps de l'arrêt Ford, mais comment en 2024, on peut délimiter la portée substantive d'une clause qui permet de déroger aux droits. Et je pense que ça peut être d'autant plus pertinent dans le contexte où, comme on le mentionnait en introduction, cette semaine, au Québec, on a un comité consultatif en matière constitutionnelle qui propose carrément une refonte là, du régime constitutionnel au pays, et il le propose de façon unilatérale, sans le faire avec collaboration avec les peuples autochtones. Alors, l'article 25 de la Charte, qui était question dont il était question dans Vuntut-Gwitchin, une disposition dont on parle très peu, c'était la première fois que la Cour suprême se prononçait sur cette disposition. Alors, l'article dit « Le fait que la présente Charte garantit certains droits et libertés ne porte pas atteinte aux droits et libertés des peuples autochtones du Canada, en anglais, shall not be construed so as to abrogate or derogate to Indigenous rights. » Et avant Vuntut-Gwitchin, on avait deux interprétations possibles. Soit finalement, ce texte-là, c'est là des fins interprétatives, soit on lui donne réellement une portée substantive, une forme de pouvoir de dérogation, et qu'il permet de faire un bouclier, finalement, d'agir comme un bouclier relativement aux choix collectifs, aux règlements et aux lois qui sont adoptés par les nations autochtones, relativement à des revendications individuelles de droit. Et donc, la Cour a conclu que c'est le cas, que l'article 25 agit bel et bien comme un bouclier, en plus de conclure que les gouvernements autochtones sont bel et bien des gouvernements au sens de l'article 32 de la Charte. Et dans cette affaire-là, on se replace en fait dans les faits. Il s'agissait d'une contestation par une membre de la Première Nation de la constitutionnalité de règles électorales qui obligeait à habiter sur la communauté pour pouvoir être une personne élue membre du Conseil. Et la Cour a conclu, faisant suite à ce que disait Mme Dixon, qu'il y avait bel et bien discrimination au sens de l'article 15, mais que l'article 25 permettait donc d'agir comme un bouclier et de confirmer la constitutionnalité de la règle. Donc, après que mon collègue ait parlé un petit peu plus en détail du contexte interprétatif qui s'applique en 2024, je vais revenir dans ma présentation sur cet arrêt Vuntut-Gwitchin parce que je pense qu'il y a plusieurs enseignements qui sont pertinents aujourd'hui relativement à la façon dont la Cour est venue délimiter la portée substantive d'une disposition de la Charte qui permet d'écarter ou de déroger à des revendications de droits individuels. Donc, il s'agisse de l'article 25 ou de l'article 33. Et donc, les deux dispositions créent une dynamique similaire. Évidemment, les objectifs ne sont pas les mêmes. À l'article 25, l'objectif est de protéger la spécificité autochtone. On va y revenir plus en détail. Mais justement, tout est là l'intérêt. C'est le processus par lequel la Cour en est venue à interpréter la portée d'une disposition qui permet de déroger au droit comme étant pas simplement sujette à une procédure qui permet de déroger tout azimut, mais comme étant une disposition qu'on doit interpréter en fonction de son objet substantif et de le définir, donc de définir et de délimiter cette portée-là en fonction de cet objet, et donc toujours en fonction du droit qui est applicable aujourd'hui quand même quelques décennies après l'arrêt Ford. Alors, je te laisse poursuivre,
Merci.
Stéphane.
Alors, faire un va-et-vient. Pour enchaîner peut-être le contexte depuis le début de l'année, sans en faire une obsession, peut-être ma conjointe aurait une autre opinion, là, mais toutes mes réflexions en termes de rédaction et de scholarship sont axés sur la clause de dérogation. 3 textes que Pierre, incidemment, les références là, vont être disponibles sur le chat pour les participants à Zoom. Les 3, essentiellement, s'intéressent parce que c'est pas mal mon créneau, l'angle d'attaque que j'aime prendre sur l'étude de plusieurs questions juridiques. Donc, axé principalement sur la dimension méthodologique. Je regarde tout d'abord l'opportunité de revenir sur l'arrêt Ford de 1988. Puis, je les mentionne parce que ça va pas mal structurer les remarques que je vais prononcer ce matin. Deuxièmement, en termes de méthodologie d'interprétation constitutionnelle en matière de charte, pour voir comment la donne a changé essentiellement depuis un certain nombre d'années si on est pour réinterpréter l'article 33. Et dans un 3e texte, et ça sera tout à la fin, j'aborderai le rôle du droit international pour aider à interpréter, réinterpréter l'article 35. Je vais surtout maintenant m'attarder sur l'aspect d'interprétation constitutionnelle, mais juste un mot avant sur l'opportunité de revenir sur l'arrêt Ford de 1988. Et on se souviendra, pour mémoire, là, cet extrait célèbre qui nous dit essentiellement, et qui est vu comme une ratio, quoique ce n'était pas au cœur de cette affaire qui concernait, on le sait, l'affichage commercial, mais la Cour nous dit, l'article, et je cite, « L'article 33 établit des exigences de forme seulement. Il n'y a aucune raison d'y voir la justification d'un examen au fond. » Fin de la citation. Un des problèmes que j'ai dans la façon que l'on comprend l'article Ford, l'arrêt Ford, pour certains, certaines, il y a quasi adoration de type religieuse, comme si c'était tout ce qui pouvait être dit maintenant et à jamais autour de l'interprétation de l'article 33. Et ça, en termes de jurisprudence de droit public, je vais le dire sans détour, ça cause un gros problème parce que par rapport à aucune autre disposition de la Charte canadienne, et on pourrait dire, par extension, n'importe quelle loi au pays, fédérale ou provinciale, on prétend que la jurisprudence est statique et qu'elle ne peut pas évoluer, s'adapter ou être complétée. Pour donner quelques exemples, l'article 15 en matière de droit de l'égalité sans discrimination a été interprété dans un premier temps, en 1989, dans l'affaire Andrews. On est venu à la charge, à la Cour suprême, dans l'affaire Law, en 1999. Et là, maintenant, le jugement de référence, c'est l'affaire CAP de 2008. Un autre exemple, l'article 32, qui concerne l'application même de la Charte canadienne des droits et libertés. Le premier arrêt de principe, on le sait, on l'étudie encore de nos jours dans nos cours de droit constitutionnel, Dolphin Delivery. Mais l'autorité la plus récente, qui a ajusté le tir en ce qui concerne l'interprétation de l'article 32, c'est Eldridge, de 1997. Et récemment, dans l'affaire Power, bien, on s'est référé justement à Eldridge en raffinant le test pour l'appliquer dans un contexte contemporain. Alors, cette idée qu'on ne peut pas revenir, puis on ne parle pas de renverser nécessairement Ford, mais venir l'adapter, le compléter pour répondre à la nouvelle réalité de l'utilisation grandement accrue de l'article 33 m'apparaît raisonnable. Enchaînons maintenant pour parler de ce que j'aime appeler, en interprétation constitutionnelle, la trilogie du tournant des années 2000, s'agissant donc de l'interprétation de la Charte. À la fois dans le discours des intervenants politiques et universitaires, et même dans les jugements, j'ai en tête en particulier la décision de la Cour d'appel du Québec dans l'affaire Organisation C, aussi connue en première instance comme étant l'affaire Hack. On interprète, on revient à l'interprétation de l'article 33 comme s'il n'y avait pas eu ce recalibrage que j'aime appeler dans les dernières années en jurisprudence de la Cour suprême du Canada, qui essentiellement est venu réitérer d'une part la méthodologie ou l'approche dite téléologique en matière d'interprétation de la Charte qui a été, on le sait, énoncée pour la première fois dans les années 80 dans l'affaire Big M Drug Mart. Donc, 3 affaires, une trilogie. Tout d'abord, l'affaire Poulain de 2019 concernait l'interprétation de l'article 11I en ce qui concerne le droit constitutionnel à la peine la moins sévère. La juge Martin, pour la majorité dans cette affaire-là, est venue réitérer et insister sur l'importance d'interpréter suivant l'objectif de la disposition d'une charte, l'approche téléologique, mais elle fait une mise en garde en disant il ne faut pas confondre l'interprétation téléologique avec l'interprétation large et libérale. Souvent, l'un mène à l'autre, mais une interprétation axée sur l'objectif d'une disposition de la charte, à l'occasion, doit inviter à ne pas aller au-delà de l'objectif. Donc, on doit donner plein effet à l'objectif, mais être prudent pour ne pas dépasser cet objectif. Une année plus tard, grand coup de barre en ce qui concerne l'interprétation constitutionnelle dans l'affaire Québec Inc. On portait sur l'interprétation de l'article 12 et ce droit constitutionnel protégé contre les peines et les traitements cruels et inusités. La question était de savoir si on pouvait la question de droit substantiel là, était de savoir si on pouvait étendre la protection de l'article 12 pour inclure les sociétés, les corporations. Et la Cour a dit non, ça se limite aux personnes physiques. Mais en ce qui concerne la méthodologie d'interprétation, je suggère gros ajustements ou recalibrage pour essentiellement ramener, réhabiliter le rôle du texte dans l'interprétation des dispositions de la Charte canadienne des droits et libertés. Pour la majorité, les juges Brown et Rowe expliquent que tout exercice d'interprétation d'une disposition de la Charte doit commencer par le texte. Ce qui mènera à une interprétation téléologique doit commencer par un examen détaillé du texte employé dans la disposition. À terme, le même message toutefois de Big M Drug Mart demeure. L'aspect téléologique est primordial. On ne doit ni aller au-delà ni au-deçà. Pas plus loin, juste assez loin, quant à l'objectif poursuivi. Une précision importante aussi qu'on effectue, c'est de dire le texte n'a pas préséance sur les autres éléments d'interprétation, mais il demeure prédominant. Le point de départ et le point, là j'enchaîne avec le 3e élément de la trilogie, qu'est-ce que la Cour suprême du Canada dans l'affaire Cité de Toronto, qui tournait surtout autour des questions de principes constitutionnels non écrits, mais qui sont maintenant, on le sait, suivant les enseignements de la majorité dans cette affaire-là, doit être accroché au texte de disposition constitutionnelle, incluant, dans un contexte de charte, une disposition de celle-ci. Et on revient pour compléter ce recalibrage méthodologique dans cette affaire-là en disant que l'interprétation téléologique est, premier chef, textuelle. On doit commencer et s'assurer d'ancrer l'exercice dans le texte de la disposition législative. Alors, qu'est-ce qu'il y en est de l'article 33? Bien, il faut comprendre le texte employé dans le cadre de cet exercice téléologique. Il y a des mots qui parlent beaucoup, qui parlent de façon significative. On retrouve dans les notes marginales le vocable de dérogation. Dans la version anglaise, on parle d'exception. Ça, c'est le point de départ, c'est dans quoi devrait être enraciné l'exercice d'interprétation. À la Cour d'appel, dans l'affaire Organisation C, à mon humble avis, et cela dit avec respect, on fait erreur quand on suggère, et je cite, que le texte de cette disposition de 33 est clair. Il s'agit de l'appliquer. Quand on dit ça, on ne donne pas prédominance au texte, on lui donne préséance. Ce n'est pas le début de l'histoire. On fait porter au texte 33 toute l'histoire de qu'est-ce que ça devrait signifier comme objectif. Or, à mon humble avis, on doit comprendre 33 comme étant une dérogation, comme étant une exception. Une exception à quoi? Une exception à l'article 32. 32 et 33 sont les deux seules dispositions qui se trouvent sous la rubrique dans la Charte qui parle de l'application de la Charte. Si on comprend la Charte dans son ensemble, qu'est-ce qu'on veut accomplir en donnant des droits constitutionnels pour obtenir un redressement en cas de violation d'une liberté fondamentale? Bien, on doit être conséquent. On ne doit pas renverser l'adage que l'exception confirme la règle, comme ça semble être suggéré par certains intervenants. Il y a un canon d'interprétation qui invite à interpréter de façon restrictive les exceptions à un principe. Et c'est à cet égard que je crois qu'on devrait recadrer le débat en rappelant essentiellement que 33 fait partie d'un ensemble de dispositions et devrait être vu comme étant une dérogation, une exception qui commande une interprétation restrictive. Sur ce, je repasse la parole à ma collègue.
Merci. Et donc, Stéphane ayant mis la table sur les règles d'interprétation qui s'appliquent aujourd'hui, je reviens avec les enseignements de l'arrêt Vuntut-Gwitchin qui s'applique, à mon avis, à l'interprétation de l'article 33. Déjà, bon, parce que c'est en vertu d'un principe de base de primauté du droit, exige la cohérence du droit, les parallèles qu'on peut faire, les similitudes qu'il y a entre les deux dispositions, tout en tenant compte des distinctions, évidemment, mais devrait nous amener donc à faire une interprétation qui est cohérente. Et on bénéficie donc d'une interprétation qui est très récente de la Cour suprême. Je vous suggère qu'il y a 3 conclusions majeures qui nous viennent de Vuntut-Gwitchin qui sont applicables à l'article 33. Premièrement, la Cour suprême a confirmé qu'une clause qui permet un pouvoir de dérogation ne doit pas être appliquée de façon préventive. La Cour suprême aurait pu, avec l'article 25, nous dire qu'elle n'examinait pas la prétention de la demanderesse à l'effet qu'il y avait eu une violation de l'article 15. La Cour suprême l'a plutôt examiné. Et ce n'est qu'après avoir conclu qu'il y avait effectivement discrimination prima facie qu'elle a fait l'exercice de savoir si la clause qu'elle appelle comme faisant un bouclier s'appliquait. Deuxièmement, et donc je conclus là-dessus, ça ramène en fait, ça amène du poids à toute cette argumentation qui nous dit, ben finalement, puis justement, comme c'est une disposition d'exception, comme le mentionnait Stéphane, ça ne devrait pas être une disposition qu'on utilise de façon superflue et excessive. Alors, si on ne se demande même pas avant s'il y a une atteinte à un droit individuel, et qu'on l'utilise de façon préventive, non seulement ça ne devient plus une exception, c'est une généralité, mais en plus, c'est comme si on l'utilisait vraiment comme une décoration un peu partout, et on pourrait l'utiliser de façon superflue. Alors, deuxièmement, et suivant les principes d'interprétation qu'expliquait mon collègue, La Cour suprême confirme que la portée substantive d'une clause qui permet la dérogation doit être déterminée en fonction de son objet en 2024 et non plus dans les années 80. Et qu'elle doit être interprétée donc également à la lumière de l'architecture constitutionnelle au sein de laquelle elle évolue. Et donc, autrement dit, elle n'est pas sujette qu'à des règles de forme. Et on le sait depuis Ford, qui était rendu dans un tout autre contexte, 6 ans même avant le renvoi sur la sécession, on a mis beaucoup d'avant l'importance des principes constitutionnels non écrits, de l'architecture constitutionnelle. On était beaucoup plus sur la procédure constitutionnelle à cette époque-là. Mais donc, on sait l'argument le plus invoqué est le fait que l'article 33 ne prévoit pas textuellement de limite d'un point de vue substantif. Il n'y en a pas non plus de limite claire qui est prévue dans l'article 25 de la Charte. Néanmoins, la Cour suprême, pour elle, ça allait de soi, en vertu des principes d'interprétation applicables en 2024, qu'elle devait examiner la disposition en fonction de son objet, effectivement, sans aller trop loin, de façon ni trop restrictive, ni trop extensive, mais d'examiner son objet et d'examiner le rôle aussi spécifique. La Cour parle donc d'une dynamique inédite, de dynamique très spécifique de ce type de disposition. Ça joue dans l'écosystème en matière des droits et libertés, parce que ça vient aussi significativement modifier les rapports majorité-minorité. De façon différente en contexte autochtone, évidemment, mais dans les deux cas, c'est une disposition qui a cette dynamique très, très spécifique. Dans le contexte de l'article 25, on arrive donc à la conclusion que la dérogation, la possibilité d'écarter des revendications individuelles, comme dans le cas de Mme Dixon, ce n'est pas tout azimut, c'est dans le cas spécifique seulement où la règle de droit adoptée par la majorité de la communauté autochtone relativement à la minorité, donc vis-à-vis donc la posture de la demanderesse, seulement lorsque cette règle de droit-là a pour objet de protéger la spécificité autochtone. Et donc, la Cour écarte d'emblée aussi et très clairement le fait que le pouvoir de dérogation pourrait s'appliquer pour protéger une loi qui serait arbitraire, par exemple. Donc, on écarte assez clairement l'arbitraire qui, de toute façon, est incompatible avec la primauté du droit, principe du constitutionnaliste. Et donc, si on s'entend pour dire qu'on doit compléter l'arrêt Ford, parce qu'il y a une procédure à être suivie, mais maintenant, on doit appliquer des principes d'interprétation actuels, mais surtout des principes constitutionnels non écrits, donc, et tels qu'ils ont été interprétés depuis les années 80, donc avec la portée qu'ils ont actuellement. Donc, l'article 33 devrait également, on devrait également rejeter la possibilité qu'il puisse s'appliquer pour protéger une disposition qui est arbitraire, à tout le moins, minimalement. Et sinon, en fait, si on l'interprétait autrement, ce serait d'interpréter l'article 33 comme étant en dehors de l'architecture constitutionnelle où il y a des principes de primauté du droit et du constitutionnalisme. Alors, ce serait de donner une interprétation non constitutionnelle à l'article 33. Donc, si on veut reconnaître que l'article 33 existe, qu'il a une portée, on doit l'interpréter en fonction de cette architecture-là. Donc, le rejet de l'arbitraire, si on revient quand même au texte, parce qu'on ne l'ignore pas, il n'y a rien qui nous dit dans l'article 33 que les normes de proportionnalité et de raisonnabilité, par exemple, de l'article 1er sont écartées. On applique le pouvoir de dérogation nonobstant les articles 2 et 7 à 15, mais pas nonobstant forcément non plus les règles de raisonnabilité qui s'appliquent en vertu de l'article 1er. Ce qui ne veut pas dire de faire échec complètement au pouvoir de dérogation, mais certains principes de base qui nous viennent donc de la common law, de la jurisprudence de l'article 1er depuis les années 80, peuvent être effectivement pertinents dans ce contexte-ci. Un principe constitutionnel non écrit dont la Cour traite très largement dans Vuntut-Gwishin est celui de la protection des minorités également. Et je mets de côté le débat selon lequel les peuples autochtones, nous ne sommes pas des minorités au sens de d'autres minorités au Canada. Ceci dit, force est de constater que les peuples autochtones sont en situation minoritaire et dans ce contexte-là, le principe de protection des minorités est particulièrement important. Et lorsque la Cour en vient à interpréter la portée à donner au pouvoir de dérogation, elle le fait en souhaitant faire une interprétation qui soit cohérente avec cet objectif de protection des minorités. Qui, évidemment, prend un autre visage lorsqu'on est en contexte autochtone. Les autochtones étant eux-mêmes en posture de minorité. Mais donc, on se souvient que ce principe qui avait été notamment discuté dans le renvoi sur la sécession de 98, donc c'est-à-dire 10 ans après Ford, déjà. Dans ce contexte-là, la Cour suprême nous disait que même en contexte hypothétique de sécession, qui prévoit finalement un réaménagement constitutionnel allant encore beaucoup plus loin que la dérogation, on ne pourrait pas le faire en violation du principe de la protection des minorités. Ce qui fait en sorte que ça s'applique d'autant plus ici. Et moi, je dirais a fortiori, si le principe de protection des minorités est venu modeler notre interprétation de l'article 25, il devrait d'autant plus limiter le pouvoir de dérogation sous 33. Pourquoi? Parce que les peuples autochtones sont dans une situation de minorité relative par rapport à l'ensemble canadien. Et donc, le but de l'article 25, entre autres, nous dit la Cour, est de permettre de protéger sa spécificité autochtone dans un contexte autrement minoritaire face au pouvoir législatif. Et malgré tout, on écarte l'arbitraire et on délimite quand même ce pouvoir de dérogation parce qu'il restera quand même des minorités relativement, donc au sein des communautés autochtones qui sont des minorités par rapport à la communauté qui, celle-ci, donc, leurs droits pourraient être violés de façon arbitraire. Mais si on parle de la clause 33, là, on est vraiment par rapport à l'affirmation d'une possibilité pour une majorité un peu absolue avec le pouvoir législatif d'imposer un choix relativement aux minorités en contexte canadien. Donc, moi, je dis a fortiori, c'est le principe de protection des minorités faisant en sorte qu'on limitait lorsqu'il est question de réconcilier la souveraineté préexistante des peuples autochtones avec la souveraineté imposée de la couronne canadienne, d'autant plus lorsqu'il est question de déroger pour imposer un pouvoir de majorité, très clairement, il y a une délimitation qui est implicite. Et troisième élément, pour terminer, qui est un enseignement important de Vuntut Gwitchin, c'est l'analyse que fait la Cour suprême de l'article 28 de la Charte. Et ça, quand même, c'est un indicateur assez important relativement au recours contre la loi 21. Article 28 de la Charte, on se souvient, qui prévoit qu'indépendamment des autres dispositions de la Charte, les droits et libertés qui y sont mentionnés sont garantis également aux personnes des deux sexes. Et c'est un argument qui a été mis de l'avant, évidemment, dans le recours contre la loi 21, en raison de la discrimination avancée découlant de l'interdiction de port de symboles religieux et du voile, en fait, dans des femmes, parce qu'il faut le nommer. Et dans le texte de l'article 33, l'article 28 n'est pas visé. Et il y a un débat qui est assez similaire qui a eu lieu, comme avec celui de l'article 25. On dit, bien, finalement, l'article 28, c'est juste à des fins interprétatives. Ça n'a pas vraiment de dents. Ça n'a pas vraiment de substance d'un point de vue juridique. Et puis, c'est à toute fin pratique la conclusion qu'a retenue la Cour d'appel dans l'affaire Hack, justement. Sauf que la Cour suprême, dans Vuntut Gwitchin, nous dit non. C'est réellement, en fait, l'article 28, une disposition qui pourrait limiter le pouvoir de dérogation, notamment sous l'article 25. Donc, il y a une portée substantive réelle. Et fait très intéressant, pour trancher Vuntut Gwitchin, la Cour suprême n'avait absolument pas à se prononcer sur la portée de l'article 28. D'autant plus que si elle voulait en discuter, elle pouvait parler simplement du paragraphe 4 de l'article 35, qui prévoit à toute fin pratique la même chose, mais en contexte autochtone. Justement, on est en train de parler de clauses spécifiques au contexte autochtone, 25, 35, pourquoi pas parler tout simplement de 35.4. Mais la Cour est très, très claire au paragraphe 173, sous même un sous-chapitre qui s'appelle « Autres limitations ». Puis elle nous dit même dans le cas d'un droit qui serait normalement priorisé, donc en vertu de la clause dérogatoire, ici 25, il peut y avoir d'autres limitations pertinentes ayant trait à l'application et à l'effet de 25, et l'article 28 est un exemple. Donc, la Cour n'avait même pas à en discuter dans le contexte, mais évidemment, on peut formuler plusieurs hypothèses, mais la Cour n'est pas sans ignorer que c'est un argument qui est très important dans le recours contre la loi 21. Alors, c'est d'autant plus intéressant de bénéficier de cette conclusion très récente.
Merci. Qu'en est-il maintenant du droit international pour notre dernier 5 minutes? Dans cette même affaire québécoise de 2020, la Cour suprême, à la majorité, et ça a été entériné ultérieurement dans l'affaire Bissonnette, quelques années plus tard, a fait aussi un ajustement significatif, a recadré, ni plus ni moins, le rôle du droit international dans l'interprétation du droit interne, en particulier en ce qui concerne la Charte canadienne des droits et libertés. L'enseignement premier, en ce qui concerne l'interlégalité, qui avait été articulé par le juge en chef Dixon dans le renvoi de 1987, demeure que ces éléments sont des sources pertinentes et persuasives, par opposition à contraignantes, bien évidemment. Ce qui est toujours au cœur d'une interprétation, c'est le droit canadien. Mais à bien des égards, y compris en ce qui concerne les droits humains, on peut aller chercher des éléments normatifs de l'international. La première précision, c'est de dire que d'aucune façon est-ce qu'on devrait comprendre ce rôle du droit international comme étant déterminant. Qu'est-ce qu'on vient bien recadrer, c'est de dire qu'il s'agit d'éléments pertinents et persuasifs qui viennent appuyer et confirmer la conclusion. Alors, qu'est-ce qu'il y en est de l'article 33? Mais ça veut dire essentiellement que c'est quelque chose qui va venir s'ajouter à une conclusion interprétative sur la base de la méthodologie d'interprétation, cette approche téléologique. Comme je l'indiquais tantôt, comprendre 33 à l'égard de l'économie de la Charte et de son objectif général, c'est-à-dire de donner un droit d'action en cas de violation d'un droit ou d'une liberté. 33 fait exception à 32 à cet égard. Pour le dire autrement, 33 a potentiellement un effet de neutraliser complètement le rôle même de cet instrument supralégislatif. C'est pas rien. Alors, qu'est-ce qu'il y en est maintenant du droit international? Comment est-ce que ça peut venir compléter, valider, ajouter à cette conclusion, la validité d'une telle conclusion interprétative? Revenons brièvement sur l'affaire Hack ou Organisation C, comme on l'appelle à la Cour d'appel du Québec, où on a refusé l'argument de droit international pour justifier une révision de l'affaire Ford. Et essentiellement, on est venu à dire que les dispositions de dérogation, en particulier l'article 4 et 5 des 2 pactes internationaux, compte tenu de leur nature et de leur portée foncièrement différente de notre article 33, qui est une bébête à nous, là, qui est vraiment très canado-canadienne, qu'il n'y avait rien à tirer du droit international, que c'était comme comparer des pommes et des oranges. Moi, à cela, je crois, puis c'est développé dans un de mes textes sur la question de l'interprétation de 33, est problématique. Pourquoi? Parce qu'on se concentre trop sur l'image que j'utilise, l'arbre, et pas suffisamment sur la forêt du droit international des droits humains. C'est certain qu'on ne peut pas comparer les dispositions de dérogation des instruments internationaux avec notre article 33, mais on peut comparer toutefois les régimes. Les régimes de protection juridique des droits humains à l'international souhaitent justement donner à l'individu qui, dans ces circonstances, devient un sujet de droit international de façon exceptionnelle, souhaitent lui donner un droit d'action. Ça, en termes de droit international des droits humains, ça a un nom, ça s'appelle avoir un droit à l'accès à la justice. Et son compagnon, là aussi, hein, un droit substantiel, qui sont souvent plaidés ensemble, c'est le droit à un redressement judiciaire. Alors, si on veut rattacher à notre instrument national, la Charte canadienne, mais ça se rattache à 32, dont 33 fait exception, et ça se rattache à 52 et 24 pour le droit à un redressement judiciaire. Et ça nous ramène à 2 causes non seulement d'une toute, je ne veux pas revenir parce que ma collègue l'a déjà très bien abordé, mais la décision de Power aussi rendue récemment par la Cour suprême du Canada qui a insisté sur ce besoin de comprendre la Charte de façon holistique, en incluant l'article 32 de concert avec les droits substantiels et les dispositions de redressement judiciaire 24 et 52, 24 de la Charte et 52 de la loi constitutionnelle de 1867. Alors, si on fait cet exercice en prenant en considération la forêt, et non pas les arbres, la forêt du droit international des droits humains, mais c'est là qu'on vient valider une interprétation qui est toujours axée sur l'objectif, non seulement de 33 qui fait exception, mais l'objectif de la loi dans son ensemble, qui souhaite, et je terminerai là-dessus avant de passer la parole à Vincent, souhaite donner une cause d'action. Parce que, ne l'oublions pas, c'est ça l'effet d'une invocation de l'article 33, c'est de mettre de côté tout ce qui permet à nos tribunaux d'exercer leur rôle de gardien de la Constitution en ce qui concerne précisément les articles 2, 7 à 15, mais c'est quand même le gros de la protection que la Charte canadienne des droits et libertés offre à tous les Canadiens et Canadiennes, Québécois et Québécoises. Sur ce, je passe la parole à mon ami Vincent qui va nous entretenir, peut-être de façon moins juridique.
J'ai pas de théorie d'interprétation des lois. Là. Je serais très mal pris de. Je serais très mal. Pour peut-être une petite anecdote, quand Stéphane m'a contacté il y a quelques mois déjà pour participer à ce panel-là, j'ai dit bravo, ça va faire plaisir. Et pas très longtemps après, en fait, il y a déjà plusieurs semaines, plusieurs mois, Stéphane et Karine m'ont envoyé leur présentation, tout ce qu'ils avaient fait. Alors, ça montre que les professeurs d'université, c'est des gens qui sont prévoyants, c'est des gens qui sont à leur affaire, ils ne sont pas à la dernière minute. Par contre, je dois vous avouer que j'avais la date sur mon calendrier. Et cette semaine, je me suis dit, ben, je vais me préparer un peu quand même. Personne qui le écoute. Pas juste trois. Je me suis préparé quand même juste pour voilà. Et finalement, il y a eu plusieurs trucs qui ont tous déboulé. Comme journaliste, parfois, on a un contrôle horaire, des fois moins. Alors, j'ai préparé ma présentation hier entre 11 h du soir et jusqu'à minuit et demi. Alors, ça donne.
Il y a des étudiants dans la salle, ils vont comprendre ça.
C'est ça. Et ça me fait plaisir d'être avec vous ici aujourd'hui. Ce que je veux vous parler, en fait, puis je pense que mon expertise, c'est peut-être un petit peu plus là, c'est un peu tout le débat dans l'opinion publique. Moi, je suis chroniqueur à la presse depuis 1 an. Avant ça, j'ai été 1 an à la page éditoriale, donc comme éditorialiste. Donc, j'ai écrit à quelques reprises sur la clause, sur le débat, sur la clause dérogatoire, sur les chartes. Je trouve que c'est important, les droits et libertés, les chartes. Et quelques années avant, j'ai publié un livre sur de vulgarisation sur les droits et libertés. Donc, moi, c'est plus le débat public, spécialement les arguments qu'on va entendre sur pourquoi ou non on devrait utiliser la clause dérogatoire. Et une question en fait, pourquoi on est ici? Bien, une des raisons pourquoi on est ici aujourd'hui, c'est que le Québec, en 2019, justement, utilise la clause dérogatoire pour la loi sur la laïcité. Et là, je pense que les collègues l'ont dit mieux. Il y a d'autres endroits au Canada anglais qui ont pris des notes, qui ont dit « Oh, attendez, on peut faire ça. » Il n'y a pas eu de grand ressac. Le gouvernement a été réélu. Et une question très importante, il n'y avait pas de réponse, c'était « Mais en 2018, est-ce qu'on a dit aux gens assez clairement « Oui, regardez, on va l'utiliser, la clause dérogatoire. » Et ça n'a pas été le cas, parce que je suis retourné voir dans les archives, le média de la campagne électorale, les articles, parce que moi, je ne me rappelais pas que clairement, en 2018, on avait dit, regardez, on veut utiliser une chose de dire, on peut avoir notre opinion sur si on devrait ou non utiliser la clause dérogatoire, particulièrement de façon préventive. Moi, je pense qu'on ne devrait pas, mais au moins, si c'est dit clairement avant de l'utiliser, déjà, ce n'est pas la même chose. Et en 2018, durant la campagne électorale, au mois d'août, la CAQ dit, là, c'est une citation de François Legault, le gouvernement de la CAQ, si nécessaire, n'hésitera pas à utiliser la clause dérogatoire. Il dit, les Québécois sont d'accord. Robert Bourassa l'a déjà utilisé. Le Québec a le droit d'utiliser la clause de non-obstant. Donc là, ce qu'on comprend dans la campagne, quand on dit si nécessaire, ça veut dire qu'elle serait utilisée après. C'est-à-dire qu'il y aurait une loi sur la laïcité. Le débat aurait lieu devant les tribunaux. Et si, un peu comme en 88, 89, j'oublie toujours, en 88, si on arrive avec une décision de la Cour suprême et que le législateur n'est pas d'accord, à ce moment-là, il a l'occasion de dire, ben moi, je vais utiliser la clause dérogatoire, comme le gouvernement l'avait fait pendant 5 ans. Pendant 5 ans. On comprend que ça va être après le jugement des tribunaux. Et là, le lendemain de l'élection, M. Legault, dans une entrevue, dit, là, il parle de recourir à la clause dérogatoire. Et là, tout à coup, les gens disent, oh, attendez, c'est pas tout à fait ça. Et le mercredi 3 octobre, donc 2 jours après l'élection, Simon-Jean Barrette, qui va être en fait, à l'époque, il n'est pas ministre de la Justice, là, mais il va le devenir, là, en tout cas, il va, en fait, non, c'est vrai, il n'a pas été à la Justice au départ, là, mais ça va devenir un ministre important du gouvernement qui va piloter ce dossier-là. Il dit, et là je cite, « Nous, notre objectif, c'est de faire en sorte que le projet de loi va préserver les droits et libertés de tous et chacun, puisqu'en vertu de l'article 1 de la Charte canadienne des droits et libertés, c'est possible de mettre certaines balises. Donc, nous sommes convaincus que notre projet de loi va respecter la Constitution canadienne. Si d'aventure il y avait une certaine contestation, on pourrait avoir recours à la clause dérogatoire, mais ça n'est pas envisagé d'entrée de jeu. » Bon, difficilement être plus clair, c'est-à-dire que la Cour ne sera pas utilisée dès le départ. On verra après le débat judiciaire. Et là, quand on dépose le projet de loi au mois de mars 2019, c'est plus ça, là. On dépose la clause de façon préventive. Il y a des débats, évidemment, et comme on le sait, il est adopté là, avec la clause dérogatoire. On voit que dans l'opinion publique, ça n'a pas été fatal, forcément, au gouvernement, parce qu'ils ont décidé de le refaire une deuxième fois pour la loi 96, pardon. Et moi, j'ai écrit là-dessus notamment, et un peu l'ironie de la chose, c'est que la loi 96, là, je vais faire attention de ne pas trop m'avancer, mais dans beaucoup des dispositions, c'est des dispositions qui, à mon humble avis de juriste qui ne pratique pas le droit, c'est des dispositions qui respectent l'article 1. On pourrait peut-être dire, par exemple, le 6 mois pour les immigrants. Ça pourrait peut-être passer plus difficilement, à mon avis, mais pour beaucoup des dispositions c'était un peu l'ironie de la chose, parce qu'on a eu un débat sur est-ce qu'on devrait utiliser la clause dérogatoire sur un projet de loi qui, et moi je l'ai écrit, c'est pas le trône de la loi 101, là. Ce sont des choses quand même, des mesures qui sont qui ne sont pas centrales à la loi 101. On peut être d'accord ou pas avec le projet de loi, mais on n'est pas dans des... c'est pas l'essence de la loi 101. Là. On vient la modifier, on vient ajouter des choses, puis on peut être d'accord avec certaines dispositions ou non. C'est ça. Ce sont plus des dispositions qui... Pour beaucoup de gens qui ont analysé, en tout cas pour beaucoup de commentateurs qui sont relativement secondaires par rapport à la protection du français. Je n'ai pas dit que ce n'était pas important. J'ai dit que ce n'était pas quand même l'essence de la loi 101, qu'on puisse avoir des services en français, que surtout la langue pour l'instruction soit en français. C'est pas, le projet de loi ne modifie pas vraiment ça. Là, où il modifie, c'est pour certains aspects très précis. Donc, la conclusion au plan politique, et je pense que si au fond, je n'apprends pas rien à personne ici, c'est qu'on peut, en pratique, ce qu'on s'est aperçu, c'est qu'on pouvait utiliser la clause dérogatoire sans enjeu là, dans l'opinion publique. Il n'y avait pas vraiment de répercussion. Si l'objectif, par exemple au Québec, la protection de la langue et la laïcité est quand même une valeur importante. Et je pense qu'aussi la CAQ, au plan politique, son grand succès, ça a été un peu de... Moi, j'aime pas ça, mais de lier laïcité avec notre définition de la loi sur la laïcité. La défense de la laïcité, c'est une valeur très importante, mais vous pouvez défendre la laïcité et en même temps dire, attendez, pour les enseignants au secondaire, oui, il peut y avoir des signes religieux. Là. Vous pouvez défendre, l'État peut être laïque. L'État québécois était laïque avant la loi sur la laïcité. Mais au point de vue politique, le Canada anglais, comme mes collègues à l'Université d'Ottawa ont dit, ont pris des notes. l'Ontario l'utilise, la Saskatchewan l'utilise, et même au Québec, cet automne, M. Legault a lancé l'idée dans le dossier, par exemple, des médecins, où on sait qu'il y a plusieurs médecins qui sont formés au Québec, quittent le régime public, aller dans le régime privé. Là, il y a des discussions, est-ce qu'on devrait faire en sorte que les médecins restent un certain nombre d'années minimales dans le régime public, parce que, ils ont été formés, on manque de médecins. Là, M. Legault a dit ouais, ben là, peut-être qu'il faudrait utiliser la clause dérogatoire. Et le débat sur le fond, moi, je doute qu'on va en arriver là, parce que, de façon générale, le gouvernement du Québec va généralement s'entend avec les médecins, mais ce que je veux dire, c'est qu'il ne semble plus y avoir de gêne à utiliser cette clause-là, alors qu'en 2018, la CAQ, clairement, disait non, attendez, peut-être qu'on va l'utiliser après le processus, mais on ne l'utilisera pas avant le processus. En 2012, quand ils sont réélus, ils disent clairement dans le programme oui, on va la réutiliser, là, après le 5 ans pour la loi sur la laïcité, donc on va la renouveler, en fait. Et donc, c'est un peu pourquoi aujourd'hui, on se pose la question sur comment, justement, où est-ce qu'on s'en va au fond avec tout ça dans le monde. Moi, et là, je vais vous exprimer un peu les arguments de pourquoi les gens qui pensent qu'on devrait l'utiliser, voici ce qui est dit de façon générale. Et moi, je suis contre ça, mais je trouve toujours intéressant d'aller débattre puis d'aller discuter de ces questions-là. Je l'ai fait notamment il y a un peu moins d'un an avec le ministre Roberge, quand il est eu le temps de renouveler la clause. On a eu une chronique qui était un peu une discussion. Ça s'appelle « Convainc-moi ». C'est une rubrique qu'on a à notre section dialogue. Il demandait de convaincre qu'il devait la renouveler. Les deux, on en discutait. Ça a donné une discussion très intéressante, mais on n'a pas resté chacun sur nos positions qui, on savait, étaient quand même assez opposés là-dessus. Et un aspect, donc, en fait, ce qu'on entend souvent, c'est, par exemple, les Québécois sont d'accord. Les Québécois sont d'accord avec ça, donc on peut le faire. Moi, en fait, dans mon travail, ce que je trouve qui est plus important, oui, j'écris des chroniques un peu sur... j'essaie quand même de véhiculer un petit peu quelles seraient les bonnes solutions dans la société pour un paquet de problèmes. Mais au fond, quand j'écris des chroniques, mon opinion, ce n'est pas ce qui est plus important. Je veux dire, moi, quand j'écris des chroniques pour le lecteur, c'est plus... Ce qui m'intéresse plus, c'est d'essayer de l'informer, d'essayer... Quand il m'a chronique, peut-être qu'il va dire « OK, je ne suis pas d'accord avec ce que le chroniqueur dit, mais au moins, j'en ai appris, ça a poussé ma réflexion, il m'a appris des choses. » Donc, moi, c'est vraiment mon objectif premier. Ce n'est pas tant de vous convaincre que j'ai raison, mais si vous avez lu mon texte, vous avez vu ma chronique, vous dites « OK, c'est intéressant, j'ai appris des choses, je ne suis peut-être pas d'accord avec lui sur tout, je pense que j'ai accompli ma mission. » Donc, c'est pour ça que moi, ce qui m'intéresse, c'est de vérifier factuellement qu'est-ce qu'il y en a. Alors, quand on dit que les Québécois sont d'accord, il n'y a pas vraiment de sondage là-dessus. Le sondage le plus près qu'on a vérifié, c'est en 2019. Donc, c'est vrai que c'est avant tout le débat. Puis 2019, là, dans ce contexte-ci, ça a peut-être changé. On a demandé aux Québécois leur niveau d'attachement à certaines institutions au Québec. Et la Charte canadienne, il y avait 69% des Québécois qui étaient attachés à la Charte canadienne. Et là, j'apprends rien à personne, en tout cas, certainement pas à Montréal. L'annonce de la Charte québécoise est probablement plus populaire que la Charte canadienne en raison de la façon dont la Charte canadienne a été adoptée. Mais le sondage d'actualité, on parle de la Charte canadienne, 69%, l'Assemblée nationale du Québec, donc les élus, 40%, l'État québécois en général, 60%. Les Québécois sont quand même assez attachés à l'État québécois, c'est normal. La loi 101, qui est très, très importante au Québec, là, 57%. Donc, dans tous ces éléments-là, c'est la Charte canadienne que, avant le débat sur la laïcité, je dois quand même mettre un débat, qui est la plus populaire. L'autre argument qu'on entend, c'est on l'a souvent utilisé. Bon, on l'a souvent utilisé, on sait, c'est un argument. Il y a le professeur Rousseau, entre autres, là, qui a fait un article là-dessus en disant on l'a utilisé. Là, je ne veux pas. C'était une vingtaine, une trentaine de fois. Et ça m'a intrigué quand j'ai vu ça. Donc, je me suis dit, je vais aller voir factuellement, est-ce que c'est vrai qu'on l'a souvent utilisé? Oui, techniquement. Puis moi, c'est pour ça que quand j'écris dans mes chroniques, je dis toujours que, au fond, elle a été utilisée avant que la CAQ arrive au pouvoir. Elle a été utilisée au Québec, c'est toujours 2 fois. Moi, j'estime que c'est vraiment 2 fois. C'est-à-dire que la première fois, le gouvernement Lévesque, pour protester contre pour le rapatriement, contre le rapatriement unilatéral de la Constitution, dit je vais l'utiliser sur toutes mes lois importantes, mais uniquement celle de la Charte canadienne. Donc, comme on le sait, on n'a pas utilisé la Charte québécoise, donc les droits demeurent. Donc, c'est un geste de protestation, mais on n'a pas enlevé de droit à personne. Moi, c'est ça, au fond, qui m'intéresse, c'est le nombre de fois on l'a utilisé, on a enlevé on a dit on va affecter vos droits concrètement, puis spécialement pour les gens dans une minorité. Dans la minorité, une des minorités. Donc, ça, au fond, ça ne compte pas vraiment, parce qu'on dit, oui, M. Lévesque l'a utilisé. Oui, mais attendez, mais ça n'a pas enlevé le droit à personne. L'autre chose, c'est pour la charge. Ça, oui, c'est vrai, on l'a utilisé pendant 5 ans. Puis là, ensuite, on ne l'a pas réutilisé. Le gouvernement Parizeau ne l'a pas, utilisé. Le gouvernement Bouchard ne l'a pas utilisé. Le gouvernement Landry ne l'a pas utilisé. Mme Marois non plus n'a pas ouvert ce débat-là pour ce qui est de l'affichage. Et ensuite, la CAQ l'a fait à 2 reprises. Les autres fois, c'est vrai que techniquement, elle est dans la loi, mais on est dans des cas où on ne parle pas d'enlever des droits à des minorités. Là, on parle dans des cas, des fois, hautement techniques. Certains cas sont plus en vigueur. Par exemple, quand il a fallu déconfessionnaliser les écoles, c'est un cas qui est un peu compliqué, mais je veux dire, on ne peut pas dire qu'on a enlevé des droits à personne là. Elle est encore en vigueur, par exemple, je pense, de mémoire, c'est 7 ou 8 lois. Et la plupart de ces lois-là, c'est des lois de régime de retraite. Où, essentiellement, dans les années au Québec, comme partout au Canada, aux États-Unis, surtout pour les enseignants, quand les femmes étaient payées moins cher que les hommes. Il y avait une discrimination salariale, c'était comme ça à l'époque, c'était pas correct, mais c'était comme ça à l'époque. Fortement pour les régimes de retraite, quand vous avez un régime de retraite, votre régime de retraite est basé sur votre salaire. Donc, quand on a dit non, on n'a pas de discrimination salariale comme ça au Québec, alors là, le législateur a adopté ces lois-là pour dire attendez, on ne va pas continuer la discrimination dans le régime de retraite, on va réajuster pour que les primes soient réajustées. Et c'est ça que quand on dit oui, mais elle est utilisée dans plein de lois encore, oui, mais attendez, là, on parle de ça. Deuxièmement, en tout cas, il n'y a pas de façon de savoir, mais je ne suis même pas convaincu qu'il y a encore des enseignantes pour lesquelles, on les a laissés dans les lois, mais là, présentement, ces gens-là, en tout cas, malheureusement, sont vraiment décédés. Je ne suis plus sûr que ça s'applique à personne. Des gens dans les années 40 qui ont enseigné, qui sont encore en vie, c'est possible. C'est ça. Et il y a certains autres exemples. Par exemple, c'est encore techniquement dans la loi pour la Charte québécoise sur la clause de dérogation sur les qu'est-ce que je dis sur j'ai un blanc sur la justice là, de la Chambre, la Cour des petites créances. Donc, on a dit, quand on a dit, écoutez, on ne veut pas de contestation des avocats. Les avocats vont dire, moi, ou les gens vont dire, écoutez, moi, j'ai le droit d'avoir un avocat. Puis la Cour des petites créances, c'est une invention fantastique pour l'accès à la justice. C'est vraiment la meilleure, en tout cas, c'est une des meilleures mesures en matière d'accès à la justice. Et là, je sais qu'il y a beaucoup d'avocats dans la salle. Là, je ne veux pas vous faire de détails. Je ne suis pas dans un groupe minoritaire défavorisé. Là, je pense désolé. Là. C'est pour ça qu'au fond, cet argument-là non plus, à mon avis, n'est vraiment pas valide. Si vous dites je veux l'utiliser pour X raisons, parfait, mais dites pas on l'a utilisé une trentaine de fois, alors qu'au fond, quand on va voir chacun des exemples, c'est très difficile dans le débat public, parce que là, on parle de choses extrêmement compliquées. Moi, je prends toujours un peu comme exemple. Quand j'écris, je pense toujours à ma mère. Je commence à expliquer ça. Ma mère, des fois, quand j'écris sur la clause dérogatoire, des fois, elle me dit ouais, là, je ne suis pas sûr que j'ai tout compris. Là. Donc, puis c'est normal. Là. Donc, l'autre chose, on l'a souvent utilisé. Ensuite, ce qu'on entend beaucoup, c'est on n'a pas adopté la Charte canadienne. Ça, mais la Charte canadienne, elle reste quand même qu'elle est là. Et moi, quand on me répond ça, quand j'écris, j'ai souvent des courriels comme ça. Je dis mais écoutez, laissez faire la Charte canadienne 2 secondes. Moi, je parle de la Charte québécoise. La Charte québécoise, on l'a adoptée. Tous les partis l'ont adoptée. Et puis, c'était, il y avait un consensus et j'espère qu'il y a encore un consensus très grand au Québec pour les lois et libertés. Il n'y a personne qui nous a forcé à adopter la Charte québécoise. Elle a été adoptée avant la Charte canadienne. Elle est aussi complète, même probablement plus complète. Donc, c'est pour ça qu'à mon avis, cet argument-là ne fonctionne pas. Et je pense que j'en avais un dernier. Donc, essentiellement, c'est beaucoup, dans le fond, en fait, d'autres choses, c'est ce qu'on entend aussi, c'est beaucoup les élus ont tranché, puis les tribunaux ne viendront pas mettre ça en question. Alors ça, c'est toute la question de quelle est votre conception de l'état de droit, quelle est votre conception du rôle des tribunaux. On estime que je pense que c'est important d'avoir une séparation des pouvoirs. Et puis bon, les tribunaux interprètent les lois. Mais c'est aussi quelque chose qu'on voit. Alors, j'aimerais juste terminer très rapidement avec une citation de René Lévesque. Parce que quand, en fait, M. Legault, actuellement, en fait, j'ai deux citations, celle de M. Legault et celle de M. Lévesque, puis c'est sûr qu'on voit que c'est deux visions très, très différentes des droits et libertés. M. Legault, cette année, disait « La clause dérogatoire, c'est un instrument qui est essentiel pour préserver l'autonomie du Québec. » Alors, c'est une vision pas la mienne, très différente. Et M. Lévesque, lui, à l'époque, disait, là, j'ouvre les guillemets, le peuple québécois s'est donné en 1975 une charte des droits et libertés de la personne qui demeure, à ce jour, l'une des plus complètes qui soit au monde. Or, une telle charte, c'est l'instrument par excellence de l'affirmation des valeurs d'un peuple. Elle exprime à la fois ses convictions les plus fondamentales et les choix et les arbitrages, pas toujours faciles, qu'il faut faire dans toute société. Alors, quand on a ce débat-là sur est-ce qu'on devrait ou non utiliser la clause dérogatoire, moi, je dis toujours aux gens qui l'utilisent souvent, je dirais que sa vision était très claire, puis moi, je suis plus d'accord avec cette vision-là. On peut avoir un débat sur est-ce qu'après le débat judiciaire, de façon temporaire, on peut l'utiliser, puis c'est quelque chose, mais l'utiliser dès le départ pour dire non, il n'y aura même pas, on ne regardera même pas l'article 1, ça ne nous intéresse pas, le législateur a décidé que c'était ça, parce que les Québécois sont d'accord. À mon avis, c'est un peu court. Alors voilà, c'est ce qu'on a.
Il nous reste environ une douzaine de minutes et on s'est entendu pour procéder de la façon suivante. On va prendre une question de Montréal en présentiel. On va inviter les questions dans les deux autres pôles à Edmonton et à Ottawa et on terminera avec une question, une courte question, s'il vous plaît, là, le temps file, les participants en Zoom. Alors, immédiatement, pour Montréal, s'il y a une question, des questions.
Juste concernant l'application de la clause dérogatoire en général. J'ai vu citer le premier ministre Cache-moi, Scott Moe ici, en 2023, en adoptant le projet de loi 137, il dit, quote unquote, our government is extremely dismayed by the judicial overreach of the court docket implementation whatever. Qu'en pensez-vous du rôle, justement, de la délégitimisation des tribunaux dans l'application de la clause dérogatoire et comment est-ce que, justement, comment est-ce que, justement, je sais qu'avec la loi 21, ça a été un peu moins le cas. Les tribunaux n'ont pas autant été délégitimisés, mais on voit de plus en plus comment est-ce que cette clause est adoptée en tandem avec des attaques sur nos institutions judiciaires et la politisation de ceux-ci. Donc, ma question, ce serait brièvement, comment est-ce que ceci, ça jouerait dans l'implémentation des chartes et comment est-ce que les tribunaux peuvent préserver leur autorité en face d'une population qui, de plus en plus, est menée à ne plus faire confiance à l'État de droit et à nos tribunaux.
Merci pour la question.
Oui, je pense que c'est une observation intéressante. Puis, justement, Vincent disait que c'était un argument qu'on entendait dans la pensée populaire, le fait de dire on va utiliser la clause dérogatoire pour finalement faire échec au gouvernement des juges. Et puis, le problème avec ça, c'est qu'on oublie, quand bien même qu'on a une idée qui est une idée bien théorique de ce qu'est un État de droit qui tranche les questions constitutionnelles. Est-ce que ça doit être dévolu au pouvoir judiciaire ou non? Mais le problème avec ça, c'est qu'on en vient à substituer à l'opinion de la majorité un régime entier qui est pensé pour protéger les droits des minorités. Et c'est ce qui fait aucun sens. J'ai trouvé ça particulièrement intéressant de savoir que ce n'était pas vrai, forcément vrai que les Québécois sont d'accord pour l'utiliser, mais quand même qu'ils seraient d'accord pour l'utiliser, tous les régimes totalitaires dans le monde. La raison pour laquelle on a adopté le régime universel de la protection des droits humains après le génocide de la Deuxième Guerre mondiale, c'est parce qu'il y avait des majorités qui étaient d'accord. mettre en place des lois qui violaient les droits des minorités. Donc, c'est grave de dire que les Québécois sont d'accord s'ils ne sont pas d'accord, mais même s'ils étaient d'accord, les majorités vont toujours être d'accord pour violer les droits des minorités. Donc, la question n'est pas là. Et ça, c'est extrêmement dangereux. Et on cache, on met complètement de côté ce débat-là pour mettre à l'avant, mais finalement, on trouve que peut-être les tribunaux ont trop de pouvoir. Dans notre régime constitutionnel, ce sont les tribunaux qui tranchent les questions constitutionnelles au bénéfice pour protéger les droits des minorités. Et déjà qu'en plus, on parle de partage des pouvoirs, qui disait déjà, je pense que c'était Brian Mulroney qui disait que finalement, non, en fait, c'était Bill Gates qui comparait et qui disait que finalement, quand on est un chef d'État au Canada, on a en réalité plus de pouvoir qu'un président des États-Unis, parce que notre séparation des pouvoirs, ici, d'un côté, on a seulement les pouvoirs politiques, il y a une superposition très, très importante entre l'exécutif et le législatif et le judiciaire. Et c'est le seul rempart qu'on a en réalité dans notre système. Donc, à moins de le révolutionner complètement, on doit reconnaître ce pouvoir aux tribunaux. Et ce qui est vraiment glissant, c'est d'en faire la question principale, alors que la question principale en matière des droits et libertés, ce n'est pas un vote populaire, ce n'est pas un quiz qu'il faut faire à chaque fois. Sinon, ça ne sert absolument à rien.
Très brièvement, pour enchaîner, judicial overreach, qu'est-ce qu'on appelle, on aime appeler au Québec, le gouvernement des juges. C'est une trame narrative, on va appeler un chat qui est populiste, qui veut monter la population, avoir des décisions qui sont peut-être plus difficiles à défendre politiquement, mais qui revient aux tribunaux. Puis moi, c'était le juge en chef Lamère, qui insistait pour dire, on ne l'a pas demandé en 82, ce pouvoir grandement accru de contrôle de la légalité, de contrôle de la constitutionnalité. Mais c'est le mouvement mondial, parce qu'on apprend, parce qu'on n'est pas les seuls au Canada et au Québec. Ce sont les enseignements, je faisais référence d'entrée de jeu, de l'après-Deuxième Guerre mondiale, et on est dans ce courant-là. Là, il y a un ressac. Évidemment, je n'apprends rien, non seulement au Canada, aux États-Unis, dans plusieurs juridictions à travers le monde. Et ça se fait autour, justement, d'un discours qui est populiste et qui attaque la branche des pouvoirs publics qui est la plus vulnérable. Hein. Je pense que c'est Eisenhower qui disait des trois pouvoirs publics, législatifs, exécutifs et judiciaires. C'est juste le judiciaire qui ne peut pas se défendre si personne vient à sa défense. Parce qu'il y a par ailleurs ce principe de réserve des membres du judiciaire. Alors, ils font juste la manger dans les dents, là, toutes les attaques, puis ils doivent juste faire avec. Là, puis nous, toutefois, on devrait garder conscience que l'enseignement de l'humanité d'après-guerre, c'est qu'il faut qu'il y ait quelqu'un qui puisse décider de façon indépendante et impartiale ces questions qui sont, je le soulignais à juste titre, antinomiques de la gouvernance par la majorité.
Oui. Les gens, parfois, sont plus complexes aussi qu'on peut se l'imaginer. En 2019, quand, justement, dans le débat de la loi sur la laïcité, on a posé des questions dans un sondage et on a demandé aux gens, est-ce que vous êtes d'accord avec l'interdiction de signes religieux pour les enseignants, les policiers? Et la loi avait, quand les gens, on leur demandait, quelle est votre position personnelle là-dessus? Il y avait à peu près 60% des Québécois qui disaient, oui, je suis d'accord avec cette interdiction-là, c'est ma vision de la laïcité. Bon, OK. Mais là, on a posé une autre question, on a dit, OK, si jamais ça va devant les tribunaux et qu'un juge indépendant dit, ouais, ça, il y a une violation des droits de ces gens-là, est-ce que après ça, vous appuyez la loi? Et c'est là qu'on était à 40-40-20, c'est-à-dire il y avait 40% qui étaient en faveur de la loi sur la laïcité, 40% qui étaient contre. Donc, on était passé de 60, l'appui à la loi était passé à peu près, là, je vois de mémoire, à peu près 60 à 40%. Donc, et il y avait un 20% des gens qui grattaient la tête en disant, oh, là, je ne le sais pas trop. Puis c'est correct, c'est des questions qui sont complexes. Donc, c'est pour ça que c'est deux questions différentes. Si on demande aux gens, vous, ça serait quoi votre règle, la règle que vous voulez? Et oui, mais attendez, on a eu ce débat-là, on a des chartes, et voici ce qu'un juge indépendant, impartial, pas parfait, personne n'est parfait, a statué. Alors là, tout à coup, il appuie la loi. En tout cas, à l'époque. Est-ce que c'est comme ça aujourd'hui? Je ne sais pas, parce que comme on sait, entre 2018, 2019 et aujourd'hui, en matière de droits et libertés, on est pas, je dirais, bon, il y a des choses qui ont changé. Mais je ne sais pas si ça.
Là, je me tourne vers le passage pour voir s'il y a des questions dans les deux autres pôles, à Edmonton, à Ottawa.
Non, il n'y a pas de question.
Par Zoom.
Non. Mais il nous reste 4 minutes.
Peut-être une autre, ben voilà, on va.
Madame, monsieur, vous êtes prof ou de journaliste, là. Je vous demande une question. Comment est-ce qu'on peut faire comprendre au commun des mortels, là, comme on dit, que la protection des droits prend son sens et est protégée si on l'accorde au plus indésirable de la société? Parce que dès qu'on commence à dire, bon, lui, on l'aime pas, ce groupe-là, on l'aime pas, donc on leur enlève, on donne justement une opportunité au gouvernement de toujours justifier plus, de toujours marginaliser plus la population pour enlever plus. Je comprends les arguments type, bon, on veut pas que les juges décident tout. Il y a aussi des arguments de dire, bon, et la majorité de la tyrannie de la minorité est une chose possible. Oui, mais je sais pas si c'est une bonne pensée, mais comment de faire comprendre aux gens que c'est en respectant les droits de ceux que tu n'aimes pas le plus, que tes propres droits vont te protéger un jour.
Je me tourne vers notre chroniqueur.
Comment faire? Ben, vous avez une bonne question. Je ne suis pas sûr que je n'ai pas une réponse. Toujours qu'on marqué en liberté, pour la liberté d'expression. On entend vouloir dire je ne suis pas d'accord avec ce que vous dites, mais je serais prêt à aller en prison pour défendre ce que vous dites. C'est de se mettre aussi parfois à la place de l'autre. On a un débat présentement sur la liberté d'expression qui est extrêmement complexe. Écoutez, puis il faut voir aussi que on voit aussi que ces questions-là, je regarde, vous avez l'air plus jeune que moi, ces questions-là sont aussi très importantes chez la jeune génération. Donc, je pense que comment faire? La première chose, c'est d'en parler. Si on n'en parle pas, si vous ne faites pas avoir votre avis, que vous en pensez, si on n'en parle pas, vraiment, peut-être que la tendance actuelle va continuer. L'autre chose, c'est peut-être aussi d'écouter un peu. C'est un équilibre délicat, mais c'est de. Moi, dans mon travail, ce que j'essaie de faire, c'est de ne pas le faire de façon trop frontale. Et puis, vous savez, les gens, des fois, sont plus complexes qu'on pense. Et puis, des fois, moi, j'étais dans un souper récemment avec une personne avec qui j'avais des opinions extrêmement différentes. Là, extrêmement différentes. Et puis, au lieu d'y aller très frontalement, puis ben, moi, je dis que c'est ça, toi, tu dis que c'est ça, bien, je sais pas, essayez d'y aller tranquillement, puis de regarder, OK, pourquoi tu penses ça? Qu'est-ce qui essayer de l'amener sur tranquillement des points communs. Toujours, c'est la technique de déplucher un oignon. On ne dépluche pas un oignon d'un seul coup, on va. Et finalement, à la fin de cette discussion-là, disons pas tant qu'on s'était rapproché, mais j'avais fait admettre certains points à la personne en disant ouais, c'est vrai que peut-être que ça, là, je ne donne pas l'exemple précis, justement, c'est une conversation privée, là. Mais c'est sûr que si on ne se parle pas, ça va être compliqué. Donc, des fois, vouloir avoir raison, c'est bien, mais de maintenir le canal de communication, c'est important aussi. Mais ce n'est pas facile. Bonne question.
Oui, juste un petit mot, puis ensuite, on va passer la parole à Edmonton.
Oui, ben, en terminant, en fait, c'est ça qu'on a tenté de faire justement dans la classe. Il y a des étudiants qui posent d'excellentes questions. C'est ça qu'on a tenté de faire un dialogue entre les différents points de vue. Et je pense que un élément qu'il ne faut pas oublier, qu'on peut peut-être rappeler aux autres aussi, parfois les convaincre, c'est en misant sur la dimension holistique des droits et libertés. La loi 21, par exemple, soulève des débats sur le port des symboles religieux. Certaines personnes, la liberté de religion, peut-être, c'est moins important qu'on puisse la violer ou qu'on puisse y déroger. Mais si vous demandez justement là à ces mêmes personnes de parler tout d'un coup de leur liberté d'expression, leur droit de s'exprimer sur le sujet, que ce soit dans les médias ou ailleurs, si vous leur dites, bien, écoutez, si on vous empêchait justement de dire votre point de vue là-dessus, si l'État vous bâillonnait, qu'est-ce que vous en penseriez? Probablement que les personnes vont me dire que c'est pas le cas. Si vous amenez même la discussion ailleurs, vous dire, ben, si on était dans un contexte où on pouvait procéder à des arrestations arbitraires, si on était dans un contexte. Et là, ensuite, vous allez trouver un droit ou une liberté qui va toucher la personne. Mais là, on ne peut pas dire, bien, parce que celle-là, elle est importante pour vous, parce que vous avez déjà une opinion majoritaire, là, dans ce cas-ci, on va la protéger, puis dans un autre cas, on va pouvoir violer les droits d'autres personnes. Donc, miser, je pense, sur cette interconnexion-là des droits et libertés, je pense qu'on qu'on finit par trouver un droit ou une liberté qui touche davantage chaque personne.
Merci.
C'est une bien meilleure réponse. La mienne était mauvaise.
Non.
C'est excellent.
C'est ça,
Question,
il y a une question, de Edmonton.
d'un auditeur, qu'est-ce qu'on fait? On fait dans l'éventualité où le juge rend une décision qui serait défavorable aux droits des femmes. La clause de dérogatoire ne peut pas permet au législatif de répondre au judiciaire le juge se trompe et rendre une décision défavorable aux droits.
Alors, excellente question. Elle aurait pu être signée par Jean Chrétien, ministre de la Justice à l'époque de rapatriement en 1982, parce que c'était grosso modo, dans ces mots-là, qu'il avait résumé le rôle potentiel de l'article 33. Réponse à une décision qui leur a échappé, comme on dirait communément, et non pas de façon à mettre de côté l'ensemble même de tous les droits et libertés que ce régime législatif vise à protéger. Alors, excellente façon pour clore le panel de Montréal. Pierre, tu as une autre?
Oui, il y en a une autre. Je
il y a une autre question.
Du parquet à Ottawa.
Ah oui, OK.
La parole est à Ottawa.
Bonjour. D'abord, je tiens à remercier les panélistes. C'était une discussion super intéressante. Mon nom est Véronique Morissette. Je suis avocate à l'Association du barreau canadien. Notre association, sans grande surprise, partage beaucoup des préoccupations qui ont été partagées aujourd'hui. Puis je ne veux pas voler le cue de mon collègue Earl Mendes qui va vous en parler un peu plus tard aujourd'hui. Mais dans le cadre de nos activités, dans le cadre de l'association, on a parlé avec certains représentants gouvernementaux qui nous ont partagé leur désir de voir la communauté juridique se mobiliser pour communiquer plus efficacement au grand public les enjeux qui se rattachent à l'utilisation de la clause non-obstant. Et j'espérais vous entendre sur cet enjeu-là et sur le rôle que vous voyez la communauté juridique occuper dans les médias.
C'est ça l'appel à l'action, hein? Le thème résumé de notre manifestation d'aujourd'hui, a call for action, un appel à l'action de façon plus large par rapport à la société civile, mais aussi en lien direct, vous le dites dans votre question, un rôle accru de la communauté juridique. J'ai le goût de terminer, parce que là, on doit clore le panel de Montréal en rappelant, on a invoqué en introduction, Marion Saint-Hélène, le rapport du comité Rousseau-Proulx, rendu en milieu de semaine. Il va falloir qu'il y ait une mobilisation parce que c'est non seulement par rapport à la recommandation numéro 10 qui, comme Marion le soulignait, suggère d'essentiellement mettre de côté la clause, les droits et libertés en invoquant la clause de dérogation par rapport à l'ensemble de la législation québécoise. Ça, c'est du omnibus, là, mais du omnibus encore avec un impact beaucoup plus large parce que je le comprends comme ayant potentiellement pour but aussi de mettre de côté en substance, comme Vincent le soulignait, aussi les protections octroyées par la Charte québécoise. Il faut se mobiliser. Par rapport à la recommandation numéro 10, mais par rapport aussi à l'attaque frontale qu'on fait du pouvoir judiciaire en le discréditant dans la lignée de cette trame narrative du gouvernement des juges qui, essentiellement, viennent les présenter comme étant contre la société civile. Ça, ce ton dans le rapport est complètement inacceptable. Il faut absolument que la communauté juridique, au premier chef dans la province de Québec, bien évidemment, mais si ça pouvait être plus large que ça, donne une réponse forte et ferme à ces recommandations de ce rapport qui, autrement, va simplement être référé, réitéré, comme si c'était la vérité et la vie du droit constitutionnel tel qu'on le comprend au Québec. Alors, si ce n'est pas ça le consensus par rapport à la protection juridique des droits humains au Québec, bien, on doit le dire haut et fort. Sur ce, mon cue, c'est « Now to you » in Edmonton, qui est le prochain panel. Je regrette, maintenant, on doit enchaîner. Alors, Richard?
Yes, hello Montreal, hello Ottawa. Can everybody hear us? Yeah. Okay, I see heads nodding, that's good. I am going to throw over immediately to Professor Lise Gattel, who's our moderator for this session, and then I'll say a few words afterwards. So, Professor Gattel, take it away.
Good morning, everyone. That was a really interesting first session. Welcome to Edmonton, where it's a very cold and snowy morning. I have to say that, you know, the preemptive use of the Notwithstanding Clause outside of Quebec is wrapped up in populist politics. And while I know that our discussion this morning will be focusing on the history of the Notwithstanding Clause in Alberta, perhaps in the question period, we could take up this more current context in which the preemptive use of the Notwithstanding Clause is being directed at violating the rights of highly stigmatized minorities like transgender and gender diverse children. So welcome this morning. We have three very great panelists. First of all, we have Richard Malley, who is the director of the Center for Constitutional Studies here, which is housed in the Faculty of Law. Dr. Malley received his LLB and LLM degrees from the University of Glasgow and his PhD from the University of Luxembourg. He's the managing editor of the Review of Constitutional Studies and Constitutional Forum, and the producer and host of the Center's Charlottetown podcast, a 5-episode mini-series that explores the history of the Charlottetown Accord. I'm going to introduce all of the panelists first. Next, we have Eric Adams, who is a professor at the University of Alberta in the Faculty of Law. He served as Vice Dean between 2019 and 22, and he publishes widely in the field of constitutional law in areas such as legal history, employment law, human rights, and legal education. His multidisciplinary research engages all aspects of Canadian constitutional law, theory, and history, including the Notwithstanding Clause, and he's currently completing a book on the exile of Japanese Canadians following the Second World War. And finally, we have Anna Lunt, who is a professor in the University of Alberta's Faculty of Law, where she researches and teaches in the areas of bankruptcy and insolvency, debtor-creditor law, civil procedure, access to justice, and housing. Her book, Trustees at Work, Financial Pressures, Emotional Labor, and Canadian Bankruptcy Law, was published in December 2019 by UBC Press, and she's the recipient of the Provost's Award for Early Achievement of Excellence in Undergraduate Teaching and the Faculty of Law's TVH Miller Teaching Award. So welcome everyone, and I'll turn it over to Richard.
Well, first of all, thanks very much, Lise, for being here and for the intros and for moderating our session today. Thank you also, of course, to Eric and Anna, our two other panelists in this session. Thank you to our students that we have in the room for coming out during, or at least on the cusp of exam season for this. And thank you as well to our co-organizers, to Errol, Marion, Stefan, and Slava. It's really been a pleasure working with all of you on this. So all I want to do in the next, let's say like 10 minutes roughly, is to offer a few introductory words just to kick things off. And I thought a good way to do that would be to provide a very brief reflection on the title of this panel, which is Lessons from the Past, the History of the Notwithstanding Clause in Alberta. And this is a title that I picked for two reasons. One, to remind us that Alberta has actually played this really outsized role in the history of the Notwithstanding Clause. And two, because I think there are affinities between where Alberta has been in its relationship with the Notwithstanding Clause and where a number of provincial communities now find themselves. And I want to focus on this regard very briefly on just one episode in Alberta's relatively recent history that I think has particular resonance right now. And that's the aftermath of the Supreme Court's well-known Breeden decision in the late 90s. So I suspect that most viewers will know this case, but for anyone who doesn't, the super short version of the story is first, that a guy called Delwyn Breeden was fired by King's College in Edmonton because of his sexuality. Second, that Alberta's human rights legislation at the time did not stop employers from discriminating against employees based on their sexuality. And third, that in the end, the Supreme Court found this was unconstitutional. And the court ruled that protection against sexuality-based discrimination should actually be read into Alberta's Human Rights Code. So that, in a very tiny, like the tiniest of nutshells, is the story of the Breeden case. But it's not a story that ended with the Supreme Court's decision. And this was because of the Notwithstanding Clause and because the clause was on the table. And because the clause was on the table, the day that the Supreme Court judgment came down was also the start, or at least the sort of focal point, of an organized, aggressive campaign to get Ralph Klein's provincial government to invoke Section 33 to suspend the effect of the Breeden decision. And it took them a week, but ultimately the Klein government decided not to cave to that campaign, although it's important to note here that it did use the clause a couple of years later in an attempt to block same-sex marriage in the province. Now, why am I talking about this to kick things off? Well, we're going to be hearing from Eric and Anna in a few moments about some of the lessons that we can learn from other aspects of Alberta's Section 33 history. But I think this episode is worth briefly honing in on as well, because although there was no invocation here, and in a certain sense, nothing therefore happened, legally speaking, the Breeden episode actually tells us quite a lot about, firstly, the promise, the Notwithstanding Clause, and secondly, about some of the more potent challenges that we face when we try to cash that promise out or take that promise seriously. So let's start with the promise. And the key point here is that when it comes to the aftermath of Breeden, there was a sharp disjoint between the government's hesitation on whether to invoke Section 33 and the sentiments of the wider Alberta public. And we can see this in post-Breeden opinion polls, insofar as polls indicated that nearly 2/3 of voters in the prairies generally actually supported the substance of Breeden, very much against the grain of the homophobic hate that was being loudly spewed at the time in editorials and letters to the Premier. And that support for Breeden was actually pretty consistent regardless of party affiliation, to the point where at least 75% of supporters of every party except Reform were in favour of the Supreme Court's ruling, and Reform supporters were actually pretty much split down the middle, roughly 50-50. The point being, there was no syncopation between the people and the government on Breeden. You had a government that was wavering on Section 33 because of pressure from core elements of its base, and a population that was pretty resolute, at least in its support of the principle underpinning the Supreme Court's decision. But this is where the promise comes in, the promise of Section 33, because the Notwithstanding Clause itself recognizes this as a problem, right? It recognizes that government alone cannot be trusted to judge its own decisions on whether to invoke. And part of the clause's solution to this is to guarantee that the government will face an election, and hence the independent oversight of the electorate before it gets the opportunity to re-invoke. So if the first lesson of Breeden for present purposes is that we can't trust government's representative capacities, well, Section 33 embodies that lesson, and it has its own electoral solution to that problem. So that's the promise, or at least one reading of the promise of Section 33, that there will be some form of accountability, there will be independent oversight beyond the government of the day, and that oversight will come from the electorate. Here's the big hitch. If this is what Section 33 is all about, if this is the ideal that underpins it, then we have a problem with follow through. And again, you can see this problem in post-read polling data, which indicates that only around 10% of voters in Alberta reported hearing a lot about the Freedom decision, with a whopping 60% reporting that they had heard nothing at all. So regardless of what the public's views were on the substance of Freedom and the principle that underpinned the Supreme Court's decision hypothetically, many people just weren't sufficiently informed. And this speaks to a larger structural problem with inferring a judgment on Section 33 from the results of a provincial election. The problem being that Section 33 isn't actually on the ballot. A specific invocation of Section 33 isn't actually on the ballot, which means that there's nothing to guarantee that voters know about an invocation or care about an invocation. And even if we do know and care, maybe we don't have a sufficiently right-sensitive perspective, and maybe we don't appreciate the constitutional and hence fundamental status of the rights that are at stake. So while the lay of the land post-Reams points to one reading of the promise of Section 33, it also points to some of the work that we need to do to actually redeem that promise and to ensure that public oversight of the government's decision isn't just an idealistic inference or attribution. It isn't just a essentially legalistic fiction. And while it's surprising in one sense that this problem, the problem of the sort of oblique, indirect nature of electoral oversight, isn't a more central theme in the literature in Section 33. Maybe that just points to the fact that we are, I think, largely caught up in these steely intellectual factions. Some of us on the sort of legislative supremacy side, some of us over on the judicial supremacy side, but too few of us thinking about what it really means to have a mechanism in our Constitution that meaningfully attempts to democratize the interpretation of rights and their limits. And so this is the challenge that I want to pose for our reflections on the Notwithstanding Clause. And the challenge is, can we affirm that promise, the promise of Section 33, without also lapsing into an insistence that we have to accept the text's imperfect execution of that promise? Now, this is actually a perfect place, I hope, to segue into Eric Adams' talk, because Eric is going to talk about former Premier Peter Lougheed's thinking about the Notwithstanding Clause, which, at least by the early 90s, had really started to evolve to confront this challenge, the challenge of saying, look, this is part of our Constitution. And you know what? Also, the history of judicial review in the US teaches us why it should be part of our Constitution. But that doesn't mean that we have to rest on our laurels and accept all of its inadequacies. We can do better. And constitutionalism has to speak to both of those impulses, right? It has to be about entrenching our commitments, yes, but also retaining the ability to evolve and rise to new challenges as and when they arrive. And certainly the uptick in provincial recourse to Section 33 over the last 6 or 7 years is such a challenge. And so we need to think about whether there are additional layers of publicly inclusive process that can provide for independent, focused, and right-sensitive, but crucially, non-judicial oversight of governmental power vis-a-vis Section 33. And I think there are lots of interesting ways of doing that, some more ambitious than others, one of which Ian Beach and I have written about recently. But I think that's a good place for me to hit the pause button on my remarks and hand over to the always wonderful Professor Eric Adams.
In this room, we're picturing thunderous applause. We can't hear it, but we're sure it's happening. And now I'm going to try and set up a system here as we get started. Sure. How am I going to advance the slides?
The advance?
Yeah. Okay, the first thing to check is hopefully that the sound is still good and that the slides are visible. I'm just going to assume that that's all the case, and thank the organizers for this terrific event and for being able to pull off a multi-city, multi-provincial inquiry into this critical provision of the Notwithstanding Clause. I want to recognize right off the bat my co-author in this work and research, third-year law student Chiara Concini, who's in the room with us. I'll be presenting, but Chiara is very much central to the project and has done much of the archival work that takes us here today. So let me start by saying, as many of you will know, that Canada's tense and dramatic patriation negotiations ended on November the 5th, 1981, with the famous Kitchen Accord, the Night of the Long Knives, and the early morning agreement between Prime Minister Trudeau and all of the provinces except Quebec to amend Canada's constitution with a Charter of Rights and Freedoms, as well as an amending formula. The consequences of that deal, the legal and political shifts that it would shortly set in motion, were not, of course, yet known, as reporters began to tell the story of how the complex constitutional agreement, so often on the brink of collapse, actually came to be. In Western Canada, at least, Peter Lougheed, Premier of Alberta, stood at the center of those newspaper accounts, which began on November the 6th. Premier Lougheed couldn't suppress a smile and a self-congratulatory slap on the back, the Calgary Herald reported. The key was, quote, the escape hatch, allowing provinces to bow out of basic freedoms and legal and equality rights in the Charter. This was really crucial, Lougheed explained to readers. I took a major role in making that an essential element of Alberta's agreement. Over or up in Edmonton, Don Braid for the Edmonton Journal said this: love the Constitutional Accord or hate it, much of the credit for devising the thing belongs to Premier Lougheed. Even, Braid noted with some disbelief, a highly placed Ontario official was prepared to give credit to Lougheed for breaking the logjam of the Charter of Rights with his idea of the Notwithstanding Clause. Once Ontario says that you're responsible, you really know you've hit the big time. When the deal threatened to break apart a few weeks later in November, Lougheed stood firm on the necessity of Section 33. The Notwithstanding Clause Lougheed announced in the Alberta legislature was fundamental. It was essential to Alberta's continued support of the Charter. Maybe are we not seeing our slides?
Yeah, let me just reshare and see if that helps.
And maybe if someone in the comments could let us know whether that worked. And Richard, if you want to just throw up the comments so we know in the chat.
Okay.
There we
Seems to
go.
be better.
Ever since.
Could you please change one slide just to see whether they're changing well on the screen? Because we see just the first one, the opening slide.
Click on it.
Okay, so that's fine. Thank you. It works. Thanks.
Thanks for bearing with us, everyone. Ever since that early reporting, following those early November deal-making moments, Peter Lougheed has been the individual most closely associated with the Charter's most controversial provision, Section 33. Despite that relationship, not as much attention has been paid to the constitutional thought that formed the basis of Lougheed's approach to entrenched rights, democracy, and the role of the Notwithstanding Clause in Canadian constitutional law, and the ways that his thinking about the Notwithstanding Clause subtly shifted over time. Under the fog that often obscures many of the details of constitution making, there's also uncertainty about when and how and to what extent the Notwithstanding Clause emerged in the patriation negotiations, and questions about who was the most responsible for pressing for it and why. That's some of the questions we aim to answer in our contribution. First, I'll begin with the question, should any of this matter? Well, beyond the intrinsic value of simply knowing our constitutional history with specificity and accuracy, there is also, we think, an inevitable feature of purposive constitutional analysis that requires us to understand the thinking of the constitutional framers. to locate threads of meaning that may help us make better sense of a provision like the Notwithstanding Clause and its place within the constitutional order. Like searching for the essence of Charles Foster Kane and Citizen Kane, the answers we seek about the origins or the essence of the Notwithstanding Clause will always be partial and sometimes conflicting. Such is the nature of constitution making and a constitution that is the product of many minds and many hands. But the questions we ask, the search in and of itself, helps to build the picture all the same. And in our view, it's a picture that matters. Our story begins, of course it does, at the University of Alberta Faculty of Law. Peter Lougheed enters law school, part of a combined arts and law program in the fall of 1949. There he is looking fresh-faced as a student. He graduates from the law school with his LLB in 1952. In his third year at the Faculty of Law, he took Canadian constitutional law. Many students will think third-year constitutional law might make better sense than first-year constitutional law, but in any event, in third year, Peter Lougheed took Canadian constitutional law from Professor Alexander Smith, one of just a handful of faculty members on the faculty at that time. Smith was one of Canada's leading experts on Canada's trade and commerce power, which presumably defined a good deal of the course, which was largely devoted to Privy Council jurisprudence, marking the boundaries between federal and provincial power. Here is a course description. Exciting doctrinal developments in 1951-52 would have included the margarine reference, which had just been decided, and whether Lougheed also encountered in those studies the reference re-persons of the Japanese race, recently decided by the Privy Council, which upheld the legality of one of Canada's most egregious rights infringements, the exile of nearly 10,000 Japanese Canadians under the War Measures Act. We do not know. How much time Peter Lougheed had for such constitutional intricacies is also unclear. As the Alberta Student Newspaper reported, during his years at the U of A, Lougheed served on the University Student Council, including as its president. He wrote for the student paper. He participated in the debate and public speaking clubs. He also played varsity football, varsity hockey, and varsity basketball. Also, if that's not enough, he played 2 seasons in the CFL during that time. He also was a part of a very talented graduating class, which included Ivan Head, close advisor to Prime Minister Trudeau in the decades ahead on both constitutional and international affairs, and for our purposes, most importantly, Merv Leach, who went on to become the Attorney General in Peter Lougheed's first provincial government after he became premier in 1971. After being sworn in as premier, Lougheed asked his former classmate and good friend Leach to draft an Alberta Bill of Rights, which would serve as the first bill the Lougheed government introduced into the Alberta legislature in 1972. It marked a new beginning of provincial politics in Alberta. The Alberta Bill of Rights was, in almost all respects, a virtual copy of Diefenbaker's federal Canadian Bill of Rights enacted in 1960, including Section 2, with its Notwithstanding Clause. I have written earlier about the rights protecting purposes of those clauses in these statutory instruments in my article on the broader history of the Notwithstanding Clause, written with Aaron Bauer. In his notes to himself for his speech in the legislature supporting the Alberta Bill of Rights, Lougheed drew specific attention to the Notwithstanding Clause. It would continue a measure of legislative supremacy, he explained, but more importantly, it would bring public and legislative pressure to bear on any government seeking in the future to invoke it. It ensured that government and legislatures would always approach questions of rights, their limits, cautiously carefully and deliberately, he argued. This essential idea stuck in Lougheed's mind. I should say something here about the methodology that Ciara and I are undertaking. We've called upon the Provincial Archives of Alberta to give us all of the material in the Lougheed files, but also in the cabinet records detailing the presence of the Notwithstanding Clause in Alberta's record keeping in this constitution-making period, especially 1978 through to the 1980s. And when you undertake these kinds of archival tasks, what you really have in your mind before it begins is the possibility that perhaps, just perhaps, you might stumble upon a yellow sticky note somewhere indicating someone's deepest thoughts. And I'm happy to report that Ciara has found such a yellow sticky note, which I'll talk about in a moment. The historical literature on the Notwithstanding Clause and its role in those deliberations places the appearance of the clause at different moments depend on who is writing that history. Sometimes it shows up late in 1981, at other times in 1980, sometimes in 1978. The archival records confirm that it was in the negotiations as early as 1978. In the closed-door deliberations between Peter Lougheed and the premiers and federal officials that began this more tense period of negotiations, Peter Lougheed expressed his concern that a charter of entrenched rights would distort Canadian parliamentary democracy by essentially Americanizing its politics by empowering judges at the expense of elected politicians. But he found another argument in those discussions more difficult to articulate. Noting the Alberta Bill of Rights, and particularly its Notwithstanding Clause, he stressed to his colleagues the importance of elected officials sharing in the responsibility of protecting rights, and not simply handing such matters exclusively to courts. True rights protection in a constitutional democracy required, he said, vigilance, the vigilance of all sectors of the political establishment. And he worried about a slackening of those muscles if rights became the exclusive purview of judges alone. This is a difficult position to explain, he said, but it is one that you feel more than you can describe logically. The Notwithstanding Clause provided Lougheed the mechanism to reconcile those complex feelings into a constitutional position, to ensure a responsibility of rights protection continued to fall on the shoulders of legislatures, not simply residing exclusively with courts, about where to draw reasonable limits on rights. In a memo drafted on November 29th, note the day, 1978, Lou Heinemann, one of his cabinet ministers, asked the premier whether Alberta should maintain its opposition to an entrenched charter or accept a charter with a Notwithstanding Clause. Lougheed ultimately came to the position of what he called Alberta's flexible position. That would define Alberta's role in these negotiations in those critical years. Despite the complexity of the constitutional endeavor of entrenching the charter, at some point in that process, before November 1981, Lougheed was able to sketch Alberta's complex objectives into 5 key points on a yellow sticky note. Objective 3, charter notwithstanding. Alongside a patrioted constitution made in Canada, equal provincial roles in the amending formula with no veto to any one province, respect for the Supreme Court of Canada, and no public referendum on the entrenchment of the charter. When the charter was adopted in April 1982, Lougheed could have placed a check mark beside each one of those 5 objectives. What did the charter end up doing? Well, the text of the Notwithstanding Clause will be familiar to you. And I argue elsewhere and again in this, this research that the Notwithstanding Clause reflects much of Peter Lougheed's vision of a balanced constitutionalism of rights protection. One key aspect of Section 33 that had not been in Lougheed's initial plans was the Sunset Clause. Late in the negotiations, Prime Minister Trudeau insisted that the Notwithstanding Clause contain a sunset provision, a limit of 5 years. Some of Lougheed's colleagues were surprised at how quickly he agreed to exactly that proposal. So long, he insisted back, as there was an ability of legislatures to reenact the provision when the 5 years ended. The reason for Lougheed's quick agreement to the Sunset Clause should not surprise us. It was perfectly in keeping with his vision for Section 33. Lougheed never defended, and he never imagined Section 33 as a sledgehammer of rights infringement, and certainly not as an end to the judicial review of rights. He believed that elected politicians should be mindful of and constrained by both politics and courts alike in their deliberations about rights and where to draw reasonable limits. But he wanted a way to ensure that legislatures were kept in the domain of rights and their protection alongside courts. When he defended the Notwithstanding Clause against some of its early critics, Lougheed most frequently pointed to the Lochner era in the United States. The time, he said, when the United States Supreme Court had got constitutional rights wrong, when they had violated the rights of employees and workers under strained constitutional interpretation. The Notwithstanding Clause in Canada would allow legislatures to protect rights in those extreme cases when courts got it very wrong. Lougheed's fundamental view of the Notwithstanding Clause would strengthen and nuance in the decades that followed. He never deviated from the idea that it was a critical feature of the Charter, but he came to regret somewhat that it had not been better drafted to reflect his constitutional ideals. He disapproved, for example, Quebec and Saskatchewan's first preemptive uses of the clause in the 1980s. Lougheed always understood the Notwithstanding Clause as a fundamentally responsive in nature, a way for legislatures to respond to specific decisions, ultimately, he said, of the Supreme Court of Canada in rare instances when courts drew the rights limit in the wrong place. A responsive Section 33, but also an embedded one, standing not outside our constitutional arrangements of judicial review, but firmly within them. He also came to believe that a higher threshold would have been better for securing democratic approval within the legislature for a legislature to invoke the Notwithstanding Clause. Not a simple majority, Lougheed came to realize, but something higher would have been better. Maybe something like 60% of the legislature. Maybe something that would have included opposition members to demonstrate, again, the seriousness of the use and also its rarity. Finally, Lougheed imagined Section 33 to place obligations on governments to always have to explain their positions on rights to citizens, to advance arguments with reason about responding to particular decisions that the legislature was disagreeing with and why. I want to end here. The Notwithstanding Clause is real. And I think it's real in at least these three senses. It's real in that it's a living provision of the Constitution and the Charter in specific. It is not going anywhere. And governments will, from time to time, use it. And its existence means, its reality in our constitutional order means, in my view, that courts will not, and that they should not, collapse its meaning with an interpretation that effectively seeks to deny that existence, to wish the Notwithstanding Clause away by adding substantive or procedural conditions on its use that do not appear in its text. But it is also real in the sense that its capacity to impact the experience of law and constitutional law and rights and freedoms in particular is very real. for the persons subjected to their potential infringement of their rights at the hands of legislatures, potentially legislatures unconstrained by charter provisions that otherwise would protect those rights and freedoms. Finally, it is real in the sense that it exists within a living constitution, subject to ongoing political and judicial interpretation of the meaning of Section 33 and its relationship to Canada's larger set of constitutional ideals and arrangements. On that, I completely agree with Professor Bolak's comments this morning. Peter Lougheed imagined a charter with a notwithstanding clause, but he did not imagine a notwithstanding clause without rights and without courts. On that view, the Quebec Court of Appeals approach that Section 33 punches holes in the charter, that it effectively disappears rights from existence during 5-year periods after it's been invoked, runs against the constitutional theories of one of Section 33's most important architects. Thank you very much.
Thanks very much, Eric. Oh, sorry.
I was
Go
just
ahead.
going to say, we're moving on to Anna.
Bear with us, Montreal and Ottawa, while we quickly do a turnaround on the PowerPoint slides.
Excuse me, could you repeat?
We're just going to quickly do a turnaround on the PowerPoint slides to bring up Anna's PowerPoints. Okay.
Did you see that, Eric? They say resounding applause.
Do this. You want to test to see if it will. Okay.
Perfect. All right. Bonjour et bienvenue à nos collègues de l'Université de Montréal et l'Université d'Ottawa. Je suis heureuse que nous avons cette chance d'apprendre les uns des autres. Hello. We're joining you today from Edmonton, Treaty 6 territory, the traditional homeland of the Métis. Thank you to the organizers. Thank you to Lise for moderating. My first law job was as Lisa's research assistant when I was a first-year law student, so this is a really nice full circle moment. I also want to thank Kenna McDowell, who has been providing research assistance with this project. I'm going to be speaking today about eugenics, Leilani Muir, and Bill 26, which I think is an important case study about the Notwithstanding Clause. But I want to start by situating the case study in the broader discussion around the Notwithstanding Clause. As we've heard from Eric, there's a 5-year sunset period in the Notwithstanding Clause, meaning that it has to be reinvoked every 5 years or it expires. And this gives the electorate a chance to vote out governments that have invoked it in a way that the electorate considers sufficiently objectionable. Now, different arguments flow from this. One is that the electorate should be the only check on government once the Notwithstanding Clause is invoked. This is an argument that's sometimes associated with Jeremy Waldron. It's also been picked up on by academics like Dwight Newman, and I'm going to circle back to this chapter of his later in my talk. Another argument is that even once the Notwithstanding Clause has been invoked, courts can still play an important role in educating the public and the legislature about whether the law infringes the charter rights. And Eric Adams and his co-author Aaron Bauer remind us that there's a dialogue going on, not just between the courts and the legislature, but the courts and the legislature and the public. Michael Powell, in a recent article, has talked about how we need to be clear-eyed about how legislatures may operate and how they may undermine the efficiency of the democratic check. He argues that the democratic check may be especially inefficient in cases where Section 33 is used to infringe the rights of minorities who cannot secure their rights through ordinary political processes, or where it's used to erode democratic institutions and thereby impede the ability of citizens to participate in democratic processes. Now, as we've heard today, these questions have an urgency to them because the Quebec Court of Appeal and the Saskatchewan Court of Appeal have both been asked to grapple with the question of whether courts should be able to grant declaratory relief once the Notwithstanding Clause has been invoked. Can they tell us that the legislation that's been subject to the Notwithstanding Clause, does it infringe charter rights? As full disclosure, I was co-counsel to one of the interveners before the Saskatchewan Court of Appeal, but I'm not talking about those submissions today. Do we have something in the chat that we need to address? Okay, looks like people are able to see the slides. So today I want to talk about Leilani Muir and the history of eugenics in Alberta. The charter has been described as Pierre Elliott Trudeau's magnificent obsession. And this case study is one of my scholarly obsessions. And I want to convince you today that it's magnificent, or at least interesting for thinking through democratic checks on the use of the Notwithstanding Clause. I can't advance.
I can. If you click on this, the slide itself, just click on.
There we go. Okay. A thumbnail version of what I'm going to be talking about starts on March 10th, 1998. Ralph Klein's progressive conservative government introduces Bill 26. There were about 3,000 people who had been sterilized under Alberta's eugenics program, and this bill purported to limit how much compensation they could get if they sued the government. The public response was so overwhelmingly negative that the very next day they stand up in the ledge and they withdraw the bill. And so in advance of today, what I wanted to understand was what happened in that 24 hours that caused the government to walk back their invocation of the Notwithstanding Clause. What does this democratic check look like in practice? But to get there, I'm going to give you a bit of a longer version of this story. So we had a negative eugenics program in Alberta for 44 years, meaning that we sterilized people who had mental illnesses or disabilities. Underlying this program were three predominant beliefs. One, that people with mental illnesses and disabilities were more likely to be socially deviant. They engaged in crimes and other immoral behavior. Two, that people with mental illnesses and disabilities were having more children than other people and therefore were growing as a percentage of the population. And three, that immigrants, especially immigrants from Eastern Europe, were more likely to have mental illnesses or disabilities. Key proponents of this program included Clarence Hinks, a doctor of psychiatry, who did a report on mental health in Alberta released in the early 1920s. The United Farmers of Alberta, they were the governing party in Alberta from 1921 to 1935. Premier John Edward Brownlee was the premier of the UFA government when we adopted negative eugenics. And Emily Murphy, who is perhaps best known as one of the famous five who brought the Persons case, did a number of public speaking engagements in support of a negative eugenics program. The UFA government passed legislation, the Sexual Sterilization Act, in 1928. The act established a four-person eugenics board that would evaluate whether or not a person qualified for sterilization under the act. Initially, people could only be sterilized with their consent, but the government felt that that was a hamper to the effectiveness of the program. So in 1937, they amended the legislation to allow for people to be sterilized without their consent. Over its 44-year existence, the Eugenics Board approved almost 5,000 people for sterilization and actually sterilized almost 3,000 of them. Often individuals who were sterilized were also institutionalized at what was then known as the Provincial Training Center for Mental Defectives in Red Deer, Alberta. And if they wanted to leave, undergoing sterilization was a condition of them being released. I want to fast forward now to Eric's talk. Peter Lougheed, he is elected in the late 1960s as the leader of the opposition. He's already dreaming up his Bill of Rights, and he's identified the eugenics program as potentially inconsistent with this vision of human rights. He has his researcher, David King, look into the legislation, and in advance of the 1971 election, the Progressive Conservative Party incorporates repealing eugenics as a platform of their party's electoral platform. They win a landslide victory in 1971. David King goes from being a researcher to being an elected MLA. The first bill that Lougheed's government introduces is the Alberta Bill of Rights. The second one is the Individual Rights Protection Act. And we heard from Richard about how that gets taken up later in Vreend. And I'm going to come back to Vreend a little bit later in this talk. The 34th bill that's introduced in that first session of Lougheed's government is the Sexual Sterilization Repeal Act, and David King gets to introduce that in the legislature. So the act is repealed. The Eugenics Board is no longer operating, but there's almost 3,000 people who have been sterilized, many without their consent, most irreversibly. Some turn to the courts to remedy this wrong. In 1987, a woman known as DLW sues the government. She had been sterilized as a 14-year-old when she was a ward of the state. She had no mental disability or illness. She did have cerebral palsy, but that should not have qualified her for sterilization. The government tries to have her matter struck on the basis of a limitations defense. They fail, and they subsequently settle the claim with her. In 1995, Leilani Muir sues the government. She had been sterilized in 1959 while confined at the provincial training school. She was admitted to the provincial training school on the basis that she was, in the language of the time, a mental defective. There was no intellectual testing done before she was admitted. The primary evidence of her mental defect was that she regularly stole food from her classmates, but it came out later that she was in an abusive family and she wasn't being fed at home. After leaving the provincial training school, she lives independently, she gets married, she wants to have a child, but she's unable to. She discovers at that point she's been sterilized. She tries to have the sterilization reversed, but she's never able to. Her claim goes to trial. The government admits liability for sterilization, but contests the amount of compensation she should get. She's also suing for compensation for the decade that she was confined at the provincial training school. The government contests liability and how much she should be paid. In 1996, Justice Veit finds the government liable for sterilization, for confinement, and awards damages, including aggravated damages of $750,000. In the aftermath of Muir's successful claim, a significant number of people who had undergone sterilization start lawsuits against the government. By 1998, over 700 of these lawsuits are pending. The government is concerned about how much they are going to have to pay. So the government's lawyers come up with Bill 26, the Institutional Confinement and Sexual Sterilization Compensation Act. The aims of the act, as per the government, are to ensure a consistent approach to compensating individuals who had undergone sterilization and to balance their right to compensation with protection of Alberta's taxpayers' dollars. Under the legislation, the government waives all defenses to sterilizations claims and limitation defenses for any other claims, for example, claims for confinement. But it limits how much compensation anyone can get to $150,000. Remember, Leilani Muir had been granted $750,000. In the legislation, the government preemptively invokes the Notwithstanding Clause to ensure that the legislation operates even if it infringes the Charter or the Alberta Bill of Rights. The explanation that the government provides for this invocation is that they want to ensure that they can resolve these matters quickly. They're concerned that lawyers will challenge the legislation, will take it all the way to the Supreme Court of Canada, and that will cause delays. A theme running through much of the government's talking points is that they want taxpayer money to go to victims of sterilization and not to their lawyers. According to Klein's after the fact account, the legislation had been presented to the PC caucus March 9th, the day before it's introduced. Only about half of the caucus is in attendance, and nobody appreciates how controversial it's going to be. Justice Minister John Havelock introduces it the next day, and the reaction in the legislature is quick and critical. Opposition members critique the decision to use the Notwithstanding Clause. They describe it as a trampling on rights, and they critique the decision to pass the bill before attempting to negotiate settlements with the victims of sterilization. And we know the very next day, it's withdrawn. So what happens in those 24 hours between Bill 26 being introduced and Bill 26 being withdrawn? There's a lot of phone calls. For those of you who don't remember, this is what phones looked like in 1998. Ralph Klein says he receives 250 phone calls. John Havelock describes receiving several hundred more. Edmonton MLA Dave Hancock says he's inundated with phone calls, mostly negative. And Labor Minister Murray Smith describes a flood of phone calls. So the public is reaching out and saying, we don't like this. In addition, the media is critical. There's critical op-eds run in both major Alberta newspapers, the Calgary Herald and the Edmonton Journal. After the bill is withdrawn, MLA Don Tanis from Southern Alberta says, was certainly watching the news and the coverage last night and reading the papers today that caused us to say, okay, let's rethink this. Victims of sterilization are also speaking out. Ken Nelson, who had undergone sterilization as a teenager, is in the legislature when the bill is introduced. He describes the invocation as a slap in the face. Leilani Muir is reached for comment. She says she's saddened that the government has decided to play tough. Victims for sterilization, or sorry, lawyers for the victims of sterilization also speak out. John Faulds, who had represented Leilani Muir in her groundbreaking litigation, is now representing several hundred more victims of sterilization, describes the legislation as heavy-handed, given the lack of efforts to negotiate settlements with the plaintiffs. Alan Garber, who's representing another group of plaintiffs, describes it as an unfair litigation tactic. He says it's like dropping a nuclear bomb into the litigation process. Academics are also speaking out, not always against the bill. Kathleen Mahoney is opposed to the bill. She's a law professor at the University of Calgary. She sees the use of the Notwithstanding Clause as inappropriate. She says, this is precisely the nightmare scenario that human rights advocates worried about. We were led to believe that the Notwithstanding Clause was for matters of national emergencies or importance, and we were told it would never be invoked against the little guy. She argues that the government should pass legislation that is reasonable and justifiable under Section 1. David Schneiderman, now at the University of Toronto, is at that point the executive director at the Centre for Constitutional Studies. He says he doesn't think that using Section 33 is necessary because he doesn't think that the limits on compensation violate the charter. Ted Morton, a political scientist at the University of Calgary, part of the conservative Calgary School, says that Bill 26 is good because otherwise the money is just going to go to lawyers anyways. Federal politicians weigh in. Conservative Ron Gitter. Ron Gitter had been elected into Lougheed's government in 1971. He was subsequently appointed as a senator in 1993. He describes the invocation of the Notwithstanding Clause as a betrayal of Lougheed's legacy. Got a quote there from him. Today's form of conservatism is much more black and white. It is sometimes mean-spirited, and it is not attuned to the human needs, as was the conservatism of the early 1970s. Liberal Minister of Justice, Anne McClellan, she's elected here from a riding in Edmonton, says that the federal government's position is that Section 33 should only be used in extraordinary circumstances. Okay. What role does Leilani Muir's case play in all of this dialogue going on in this 24-hour period? Well, there's very clearly a dialogue between the legislature and the courts going on. Bill 26 was drafted in response to the Muir case. It addresses the different types of claims that were advanced by Muir, and it curtails future claimants from getting compensation in the specific ways that Muir did. One of the issues in the Muir case was whether or not she should get prejudgment interest running from her sterilization in 1959 to the time that she actually got her award in 1996. The government had argued that she shouldn't receive prejudgment interest because there'd been such a delay in her starting her litigation. They were unsuccessful. She got prejudgment interest. Bill 26 then precludes victims of sterilization from being awarded prejudgment interest. The government took the position that compensation in Muir was too high. In the debates on Bill 26, they note that their lawyers had located 17 cases in Canada where claims had been brought for sterilization and compensation awarded ran from $0 to $250,000 with an average of $65,000. So their view is that $150,000 is actually a pretty fair amount. There's another conversation going on though. The Bill 26 is introduced on March 10, 1998. At this point, the Vreend case that Richard talked about has been heard by the Supreme Court of Canada, and we're awaiting a decision on it. We don't know at the time, but that decision will come out a few weeks later on April 2nd, 1998. And the Supreme Court of Canada will hold that the Individual Rights Protection Act infringes the Charter because it does not protect LGBTQ people from discrimination on the basis of sexual orientation. Everyone at this moment in time, before we get the Breen decision, is aware that if the government loses, it may invoke Section 33, and there's no consensus on whether or not it should. Bill 26 is seen as potentially setting a precedent. Even after it's withdrawn, Klein refuses to make any promises that he won't invoke it again with respect to Breen, but he does promise that there will be public consultation before they try and invoke it again. Okay. What about this question of educating the public? Is the Muir decision being taken up by the public? Muir is repeatedly cited in media coverage as a benchmark for what compensation is due to sterilization victims. And it's worth pausing here and remembering that Muir had not ruled on the constitutionality of Bill 26. Rather, it had spoken to the severity of the harm experienced by victims of sterilization and how much money they needed to make up for that. Some commentators are extremely critical of the amount she is awarded, but others see potential unfairness in the significant difference between what Muir is getting, $750,000, and the compensation limits in the Bill 26. A repeatedly used phrase as the government's bullying victims of sterilization. But it's not just a dialogue between the legislature and the courts and the public. There's other levels of government, there's media, there's academics, the legal profession. Those most directly impacted are finding a way to make their voices heard, the victims of sterilization. I want to suggest here that it's not just democratic dialogue, but a democratic cacophony. This cacophony expands as we zoom out from the 24 hours of public debate over Bill 26, because Bill 26 debate occurs 70 years after sexual sterilization legislation is initially passed. And during those 7 decades, multiple people, organizations, and institutions have played an important role in shaping public opinion about sterilization, and especially sterilization as a violation of human rights. One of the early groups speaking out against sterilization were Catholic organizations who write to the government in the 1940s and the 1960s, flagging that the forced sterilization of Catholics is a violation of their religious freedoms. In 1967, the social credit government hires W.R.N. Blair, who's the head of the Department of Psychology at the University of Calgary, to write a report on mental health in Alberta. This is published in 1969. He finds that the eugenics program is justified, but criticizes how it's being implemented. Later, when Lougheed repeals the act, he tables a letter from Blair saying he's changed his mind and actually they should repeal it. Timothy Christian is a professor at this law faculty at the University of Alberta. He carries out a really influential study released in 1973, looking at how the eugenics program actually operated. He finds that certain groups are disproportionately sterilized under the legislation: women, Catholics, Eastern Europeans, and Indigenous peoples. There's a lot of activity by law reform institutes. The Law Reform Commission of Canada writes an influential report in 1979 on whether people who lack intellectual capacity should be able to undergo sterilization. Sterilization had been used in the context of the eugenic program in Alberta, but it was a bigger question because it's also a popular form of birth control. In the Law Reform Commission of Canada's report, they look at sterilization and human rights based on what's available at that point in time: the UN Declaration of Human Rights, the Canadian Bill of Rights, the UN Declaration on the Rights of Disabled People. Alberta's Law Reform Institute undertakes a research project into sterilization in the late 1980s, and it explicitly considers whether sterilization for reasons other than addressing a health concern violate the Charter. They flag potential concerns around sections 7, 12, and 15. Finally, there's an important decision in 1986 from the Supreme Court of Canada, re-Eve, looking at whether a court can authorize sterilization of an adult with an intellectual disability, find that they cannot without legislative without specific legislation allowing them to. They are presented with a number of charter arguments that they really don't take up. But what they do is they reject many of the arguments that are commonly made in favor of sterilization for social purposes, including the idea that persons with disabilities are unable to parent children. And they also acknowledge the serious harm that flows from sterilization. So when you look at all of this, you can see that it took Albertans a long time to recognize that its eugenics program was deeply flawed and that forced sterilizations were a serious violation that required compensation. And this came about through a sustained dialogue. Courts played an important role, so did other institutions, media, legislatures, church, legal academics, law reform institutes, and the legal profession. One thing that strikes me as I think about this case is how some of these institutions have been weakened. We can talk about the slow erosion of traditional media. We can talk about the growing distrust of academic expertise. We can talk about the fact that we haven't had a federal law reform commission until just recently. And so as these traditional sources of dialogue are being eroded, are there other institutions that can ensure we hear the voices of those who are most directly affected, especially when those voices are vulnerable minorities? And query, do courts have a more important role to play in this contemporary context to speak to these issues? In the chapter I referenced earlier by Dwight Newman, he has this beautiful quote where he says, "Constitutions are not magical. They cannot be the sum of our hopes and dreams. Constitutions structure a civic space in which we must discuss and debate." And in his chapter, he expresses a concern that allowing courts to offer their legal interpretation after the Notwithstanding Clause has been invoked absolves the public and legislatures from deliberating on questions of rights. I think that the Muir case suggests that courts are an important voice in the democratic cacophony, but they're not the only one, and they don't shut down debate. You very clearly see other actors engaging with and pushing back against the court's view on sterilization. I think another thing that we can take from the Muir case is that if we do get court decisions that say we can't weigh in after the Notwithstanding Clause has been invoked, we need to look to some of these other voices to step in. And I want to pause and just acknowledge my colleague Eric Adams, who has played a huge role here in Alberta in terms of educating the public about the Constitution, and that's really important labor that doesn't always go recognized. A second thing that strikes me about the Muir case, and we had Deborah Thompson from McGill speaking at a Center for Constitutional Events earlier this week, and she reminded us that democracy isn't just electoral spectacles. I think because of the Sunset Clause, much of the conversation around democratic checks focuses on the importance of elections. They have to happen every 5 years. You can kick the government out. But Muir exemplifies how democracy is ongoing. It happens between elections too. In the Bill 26 case, it happened in a 24-hour period. Third, I think one of the things that really haunts me about the Muir case is how much suffering was caused by legislating in a way that disregarded people's fundamental human rights on the basis of what even in 1928, when they passed the bill, was really questionable science. And I think in the current context where Section 33 is being raised, that's an important message too.
So we have some time for questions. We have some time for questions and comments in the room and on Zoom. So do we have anyone first here who would like to ask a question?
If there's no one in the room, Sarah Mendes, can I ask a question?
Of course, yes.
Okay, great. And this is a question for Richard and for Eric, and it ties in with your description of what Peter Lougheed said. I'm going to show my age, but as a young professor at the University of Alberta Law School, when Lougheed came to the law faculty, there was a discussion of how he was involved in the charter and the notwithstanding. And if I remember correctly, he actually said that he would not support a preemptive use of the clause. And moreover, he was, as Eric actually mentioned, was in favor of having a more than a majority vote to establish it. There would be a supermajority. There should be a supermajority. Now, is there any documentation to that effect? If I remember correctly, someone had written down what he said, and I had it at one point, but I kind of lost it. So going into your archives, can you find out where that document exists? Because if we can find that authentic document from Peter Lougheed, one of the founders of the Charter and Section 33, that would be very useful for us to have if we could try and develop a public recognition of the earliest forms of Section 33, and maybe try and get a national dialogue going on reestablishing Peter Lougheed's view of what should happen with Bill 33.
Yep, thanks for the question, Errol. Nice to see you. I can say that those remarks are published. They're even available on the center's website in a piece that they published on behalf of Peter Lougheed in, I think, 1998. His reflections on the subsequent uses of the Notwithstanding Clause. So yeah, I think it's not a stretch to have to say what his views were. He put them to paper.
Can you send us copies of that, as many as you can, because we would love to have that distributed.
You know what, Errol? I probably have enough copies in my office to send to everybody in the room right now. There's a big stack of them.
Thank you.
So I think. I heard you say 1991. I think maybe the original remarks were from around then. And then the centre published the lecture, I suspect in response to the case that Anna talked about and in response to Vreemd as well. I can't remember the exact date of publication, but my suspicion is that it was post the Vreemd decision and after the decision not to invoke the Notwithstanding Clause in response to it. But yes, I will follow up with you by email and we'll send you some copies of Peter Lougheed's remarks.
Of course, when you say something is in the mail right now in Canada, it's not a guarantee.
Thank you. It's Brent Cotter here in Ottawa. Thank you very much for really outstanding and invigorating presentations. I wanted to make one comment in relation to Anna, to your presentation. Hi, it's nice to see you again. I had the opportunity not too long after the time frame that you were discussing with respect to the cases concerning forced sterilization to have a private conversation with Premier Klein, in which he was quite noticeably frank about his view about the way in which judges and lawyers were treating him on these questions. He was particularly frank because the discussion took place in the bar of the Westin Hotel here in Ottawa at about 1 a.m. and he'd imbibed a little, I think. And it was motivated by the conversations that you have just been sharing with us. I won't say more about that. I did want to, in a more serious vein, pose a proposition to you, Eric, and invite your viewpoints. Again, thank you very much for the presentation. If I may say so, from the perspective of Saskatchewan, and I think you know where I'm going, you have kind of made this presentation as though Peter Lougheed was the hero of the Notwithstanding Clause, period, full stop. You'll know, for example, that at the Kitchen Accord, there was no one from Alberta present. The Notwithstanding Clause was a critical part of the conclusion of the Accord. And I want to just pursue your reflections on Alan Blakeney's views. He, along with Lougheed, was an architect of the establishment of the Notwithstanding Clause. His views were, I think, slightly different philosophically from those of Mr. Lougheed, and in fact held his views till the day he died and didn't moderate the views in the way in which Mr. Lougheed did. But his greater concern, as it has been articulated to me by him, he spent about 15 years as a visiting scholar at the law school in Saskatoon. We had trouble getting rid of him. Want to, quite frankly. But his concerns were more related to the ways in which courts might interpret and acknowledge individual and let me call them private rights in a constitutional way that comprised non-constitutionally protected rights that one might think of as part of a grander public enterprise. And the best example, I think, that concerned him was Medicare. And if you'll recall the Shauli decision by the Supreme Court of Canada that created some degree of scope for private medical care in Quebec. And those concerns, it seems to me, are, if not larger, of a different nature than the ones that we've just been talking about, the ways in which the courts might have acknowledged one private right that people may not entirely agree with. And I'm wondering about your perspective on that. I haven't written on the great contribution that Saskatchewan made to the patriation exercise and the Constitution, but you've inspired me to do so. But I'd be interested in that slightly different dimension of rights that are potentially jeopardized from the point of view of Mr. Blakeney.
Thanks for the questions, Senator. And of course, you're absolutely right that Peter Lougheed gets a lot of attention in relation to the Notwithstanding Clause, but he's hardly alone in pressing for it during the negotiations. And each premier that was doing so, I think, had subtle differences between them about their particular constitutional ideologies and positions on the question. So another name to throw in the mix is Sterling Lyon, the Premier of Manitoba. He certainly was strongly advocating for a Notwithstanding Clause. And in particular, you'd say he was the most of the view that to the greatest extent that the Charter could be reduced, the better, because he simply didn't agree with the principle in the first place. I don't regard that at all to have been the position of Alan Blakeney, who, as you say, was highly influential. And of course, the Saskatchewan delegation is front and center in the Kitchen Accord, and we're often a conduit between various factions and making connections to both Ontario and the federal government. So just because I wanted Peter Lougheed to be the focus of my remarks, it wasn't intended to say that obviously there aren't other hugely influential forces. I think you're right that Blakeney has in mind a slightly different set of concerns, and he put those on paper too. He's published his views on his human rights protecting purposes of the Notwithstanding Clause. He was clearly concerned about taxation. He was concerned about a conservative Supreme Court of Canada. He was concerned about the loss of Medicare under conception of private rights. And I don't regard that as fundamentally different than Lougheed, although those might not have been the particular rights concerns that Lougheed always advanced. Those positions really worked in tandem with one another, and both of them, I think, shared more than they diverged in their views on the Notwithstanding Clause. I'll leave it there.
I believe we have time for one more question, and there's, I think, one more question in Ottawa.
Hello. Hi, everyone. It's Vanessa McDonnell. Nice to see all of you. And thank you, Anna and Richard and Eric, for your really interesting interventions. So my question is for Anna, but then perhaps indirectly for Richard and Eric as well. One of the really interesting things about this panel is the way that you highlighted non-uses of the clause, sort of threatened uses of the clause that did not come to fruition. And in this respect, I suppose I'm also thinking about a recent such episode in Ontario where the Ontario government, they did use, I believe, the Notwithstanding Clause in the context of provincial labor legislation and then repealed it within, a week or so. So I guess I'm wondering, whether as scholars we've systematically downplayed this kind of category of engagement with the clause, and whether this becomes more important now in telling the story about political and democratic engagement around the use of the clause. And so just any thoughts you have in terms of how these case studies that you've presented today should feed into kind of our wider narrative about, in a context where the argument for using the clause is often an argument from democracy. And I think your case studies show that the argument from democracy is actually, far more complicated.
Yeah, thank you for that question, Vanessa. I think as legal scholars, we tend to focus on things where there's, judicial decisions that we can comment on, or laws that are passed that we could comment on. And so I think that you're right that we sometimes tend to miss those things that don't happen. I'm putting that in scare quotes, in ways that create sort of the traditional legal resources that we're used to speaking about and commenting on. So I think that these are important cases to look at, and I'm not sure, do you guys want to add anything else?
I guess I would just say that there's a kind of an irony here in that maybe the groups that are most likely to launch a successful counter democratic action against the Notwithstanding Clause are those with the widest reach of political support, that is the least vulnerable. So it's not that surprising that the most recent version of that is the labor movement, which were able to very quickly marshal widespread organized support. That's what labor movements do. The more vulnerable the rights community, the less capable they will be of doing that exact thing. So I think there is a way in which the democracy responding aspects of the Notwithstanding Clause are also complicated by features of vulnerable groups when their rights are under infringement.
It's a very good point. Okay, we have 2 more questions from Montreal, but we only have a few minutes, so I'll ask questioners to keep their questions brief and responses.
Maybe we'll collect them both.
Yeah, we'll collect them both. So,
on va les poser un après l'autre, puis ils répondront les deux ensemble, si ça vous convient? Allez-y.
Who went first?
Oui.
All right, so on that last point, I do find it very interesting how you're discussing how more vulnerable populations struggle to have their voices heard. And that is indeed something I'm noticing, especially in that of bills which many people allegedly consider, very unjust, especially recent Alberta bills 26, 27, and 29 targeting transgender youth in Alberta. So I'm wondering, is there a means, using which you would believe that people who are most targeted by the Notwithstanding Clause, people who are most vulnerable to the application of Section 33 against their interests, are able to advocate for themselves, especially in a context in which they are facing disproportionate amounts of attacks, disproportionate amounts of hatred, and other factors preventing their civic engagement and preventing them from exercising their democratic rights in a way which would comply with, so many of these grand theories about the Notwithstanding Clause that were initially thought of in the 1980s. It's not as if, it's not as if we currently live in an era in which, modern versions of what I would argue is unconscionable legislation is like so broadly unpopular that these voices are being actively transformed, because currently that is not what I'm seeing. And I'm wondering, how would that be something which can be addressed?
Maybe the other question, and you can answer both of them at the same time so that we can close the second battle. Monsieur?
So, sorry, mine's quite different. It's a comment and a question. It's, I know from someone who worked with then Premier Blakeney that when he looked at the draft of Section 15, my colleague told me that Blakeney said, I want a memo on the back decision, which was the US Supreme Court case in, I think, the late 70s, challenging affirmative action. And it suddenly made me think, in line with the papers we heard this morning from Montreal, if we're going to look at section 33 in the context of the charter, people talked about section 32 and section 1. Maybe we should also look at section 15.2, right, which operates as a kind of notwithstanding equality rights provision.
And also we might think about section 28 in the same vein. So do we have responses to these questions? I think anybody? Anna, maybe?
I'm just thinking about the first question and how you platform voices of vulnerable minorities in a moment that's really quite different from 1998 when we had the Bill 26 debate here. And you know, in 1998, what really struck me was how many journalists we had covering this issue and reaching out to people who had been impacted by sterilization. And we just don't have that sort of capacity in the traditional media anymore. I mean, one answer, and this is probably like the lawyer's answer, is that litigation is a really important form of storytelling. In the Leilani Muir decision, they told not only Leilani Muir's story, but the story of sterilization in Alberta, in part through an expert report commissioned from our former colleague, Gerald Robertson, which again drew on the law reform reports and Timothy Christian's report to really talk about how problematic a program that had been both in its underlying beliefs and in its discriminatory implementation. So I think that there is scope within litigation to platform those voices, to tell those stories in a way that touches on sort of the bigger systems. But again, that's the lawyer's answer. Of course, the lawyer's answer is litigation.
I would just say, you know, no one thinks they're a bad guy in history. So the legislators that are bringing about legislation that with the notwithstanding clause have their reasons for doing so, and they are able to couch those arguments often in the language of rights. So it's rights for parents, it's rights for biological girls in sports, it's rights for a secular society, whatever is the rights argument, those are being made and marshaled by individuals and legislators that think that the notwithstanding clause has a perfectly appropriate place and is doing that role in legislation that other people view entirely differently. So how do you bridge and reconcile these kinds of divides on rights? Well, there's no one answer, except that in my view, we need all of us engaged in the conversation productively, and that means courts, legislatures, and public. Doesn't mean we always get to the right and fair answer from everybody's perspective, but it gives us the best shot that we've got.
Can I have the final word?
Yes, you can. Thank you, Richard.
I agree completely with Eric. So I think that triangular people-led court relationship is super important. I think Anna's presentation did a great job of showing just how complicated dialogue is beyond just that triangular relationship. I think like the least that we can expect is meaningful dialogue pre-invocation, and that's something that you're not seeing enough with some recent invocations. And like at a very specific procedural level, I think that the least that you can expect is dedicated legislative committees that can hear from people that stand to be affected by a proposed law, that can hear from rights advocacy groups, that can hear from people supportive of the law, that can hear a broad spectrum of public opinion, so that legislation is not getting rammed through sort of over and above a dialogue that is taking place out there. So I think more focused, and I mentioned this in my presentation as well, more focused and more rights-sensitive dialogue that centers the views and the perspectives of people that stand to be affected, I think is really critical.
Well, thank you. That was a fantastic panel and many good questions. I think we're running late, so I'd like to close this session. And yes, thank you for letting me chair it.
Thank you very much, University. We greatly appreciate everything you've done to help us put this together. So my name is Errol Mendez. I'm a professor of law at the university here and also president of the International Commission of Jurists Canada. So the title of our panel is Back to the Future, the Ontario Experience and Looking Forward. Retour de l'expérience ontarienne et les perspectives d'avenir. So the panelists today, in addition to myself, will be Marion Sandilands, who is also an ICJ Canada director. She's also a partner at Conway Litigation. And I have to add, Marion, she is the most productive practicing lawyer that I know of. She keeps on pushing out articles and chapters. I asked her to do a chapter on Section 33 just a few months ago. She said, no problem, I'll do it in a month. So incredible. You haven't done it, is it? I haven't done it in a month. In a month, okay. And then after her was Senator Peter Harder, who is from the Senate of Canada. I knew Peter when he was deputy minister, and you seemed much more amazingly less intimidating than when I first met you when you were deputy minister. Thank you. I look forward to your presentations. And then we have a discussant, Anthea Rage, an old friend of mine, who's the national columnist for the Toronto Star. So I'm going to start having the being the thing. I'm not going to sit down because I want to see whether it works and whether or not you want to have the choice, depending on how you feel, to come and do this too. So those who support, put this on. Can you hear me? Okay. Those who support the existence of Section 33, the Notwithstanding Clause, argues that it provides a democratic check on the judiciary straying outside its role under our Constitution's separation of power between the legislature and the judiciary. Turning our attention to how this support for the clause functioned in Ontario, we have seen in the last few years, the Ford government has used the clause not to uphold the democratic will of the elected legislature, but to use the clause to fulfill the unpredictable and autocratic wishes of the executive himself in his government. Now, the best example of that is that this trigger became apparent, this autocratic trigger became apparent in 2018 when the Superior Court Justice struck down Premier Ford's plan to cut down Toronto's City Council to 25 wards from the original 47. The justice basically found that this was a violation of freedom of expression. The judge also ruled that it was a freedom of expression to the candidates who would be losing their contested awards and their interaction with the voters that they would be losing. Almost immediately, Premier Ford said he would invoke Section 33 to bring back into something that he has long cherished, to severely cut the council, which actually goes a long way back even to his brother's time. Ontario appealed and moved to stay the judgment pending the appeal. The Court of Appeal granted the stay. And on October 22nd, 2018, the municipal election proceeded on the basis of the 25-ward structure. The Court of Appeal later allowed the appeal, finding no limit on freedom of expression under the Charter. Given this ruling, Ford withdrew his threat to use the clause, and the city appealed to the Supreme Court. Sadly, the Supreme Court, by a slim 5-4 majority with a strong dissenting opinion, upheld this election disrupting statute, which was only enforced after the start of the traditional municipal election campaign period. As co-counsel in the intervener in the Supreme Court of Canada for the International Commission of Jurists Canada, we were saddened by the conclusion of the majority that the freedom of expression did not apply, as the city's claim was to try and have a positive platform which ignores the fact that what Ford was aiming for was a massive disruption in the middle of an election, essentially wiping out the existing, not a new one, but wiping out the existing political platforms between voters and the candidates. So it was an election format which the previous election councillors in the city had approved. And keep in mind that it is the largest city in Canada. It has potentially the type of political clout that one would expect a premier to basically conform to. But in fact, he basically regarded the whole thing as his personal tool to try and achieve what he wanted, and goes a long way back to his antagonism between the previous council. Now, in our preparation for the oral arguments at the Supreme Court, if given the time, we really wanted to ask the court the following questions. What if instead of reducing from 45 wards, Ford had said, I want to go beyond just 25. What if he said, I just want 10 wards? What if he went even less? Would there be any limits to the autocracy of an executive who wants to tamper with the elections in Canada's largest city? Now, as interveners, we were prepared to argue, and this we knew was a Hail Mary pass, but we were going to do it anyway, to argue the unwritten principles of the Constitution, especially the democracy, constitutionalism, and the rule of law principles, which was created under the Quebec secession reference, which could possibly have been used to deny that the Premier Ford had to have limits in how he would reshape the nature of a vote in the middle of an election. However, the slim majority of the court decided to limit the unwritten principles only as aids to interpreting the constitutional text or to fill in textual gaps. And they claimed that to do otherwise would be interfering with the legislature's authority to amend the Constitution and even undermine the application of Section 1 and Section 33, which we completely argued against. Now, much to our surprise and pleasure, there was a strong dissent which correctly elevated the unwritten principles to the most basic and normative commitments, their words, not mine, from which the specific textual principles derive. In other words, the constitutional text emanates from the unwritten principles. According to the strong dissent, the text is not exhaustive of the Constitution. We were really pleased that the dissent actually asserted the one clause which we really wanted them to say. The unwritten constitutional principles are a key part of what makes the tree grow. Our tree of democracy, which the metaphor was first created in the Edwards and Attorney General of Canada ruling, which talks about the Constitution being a living tree capable of growth and expansion. Now, using these type of approaches, there's no doubt that the dissenting opinion by Justice Abella, Karakatsanis, Justice Martin, and Kassir basically said that there is no doubt that these principles could possibly have invalidated the legislation. So it's a very strong minority dissent. And this is my dearest hope, that this strong dissent by a strong court would one day lead to a majority ruling by the court that there are limits to the autocratic use of the clause by an executive of the federal or provincial legislatures, such as the one used by Ford. That is the reason why we wanted to ask those questions, and we were very sorry we only had 5 minutes. There's not much you can do in 5 minutes when you're trying to create a very complex argument in front of the court. And we're desperate to find another case. Maybe we will soon when there's an appeal in the Bill 21 case. But anyway, that's basically one of the areas which, yes, we were disappointed, but we had hopes that maybe based on that dissent, there could be further ways in which to sort of put a limit on the autocratic use of the Notwithstanding Clause. But not so long after this case, there was another use, an autocratic use by the Ford government in another blatant political fashion with the 2022 provincial election. Yet again, the trigger was a decision of the Ontario Superior Court, which struck down portions of the Ford government's Election Finance Act, which seemed to have the political aim of curtailing third-party election spending way, way further back than the period which normally was allowed for that limitation of third-party spending, mainly to curtail the advertising of the greatest adversaries of the government, the unions. Guess what? The Premier recalled the legislature from the summer break to add the Notwithstanding Clause to shield his limitation on the advertising by his chief adversaries. The union again appealed to the Court of Appeal on the basis of a violation of the democratic rights in Section 3 of the Charter. And the court said, well, maybe because it's a non-derogable right, maybe we can use the non-derogable rights to put the limits on the autocratic use of the clause. And so given the fact that the democratic rights are not basically possibly vulnerable to the Notwithstanding Clause, there is no doubt that we knew that the government would appeal to the Supreme Court, and they have. Now, in the court, the lawyers for the unions argued that they should uphold the Court of Appeal's decision to use the non-derogable right in Section 3 to be a kind of guardian against the autocratic use of the clause. Now, two of the interveners in this clause, in this hearing, Marilyn Sandilands and myself, acting as co-counsels for the interveners, urged the court to understand that given Section 3 is one of the few non-derogable rights protected against the use of the clause, the court should give a large and liberal interpretation of the right. Because, to use Marion's very poetic words, given the hanging knife of an autocratic use of Section 33 threatening in the background, there should be a large and liberal approach to these rights. That's the second autocratic use. The third one, which happened then in November of 2022, is when the Ford government passed Bill 28, imposing a 4-year contract on over 50,000 education support workers. Now, this time, I think the clause was invoked because they knew this time that there would be a judicial decision against them, because the Supreme Court had already said that there was a right to strike in the pursuit of a collective agreement. So again, he decided, I'm going to be preemptive this time and use the clause in a preemptive fashion. Well, I contest that the preemptive use is the worst use of the autocratic use of the clause. Why? First, because it strongly suggested that the use is a betrayal of the very foundations of the Charter. There is sufficient evidence of the original agreement by the premiers and the Prime Minister of Pierre Elliott Trudeau that Section 33 would only be used as a safety valve against judicial decisions that could undermine the vital interests of society. And that's the reason why I asked the University of Alberta to get those documents, because I need those documents to show that at least one of the architects was firmly behind that position. Second, the preemptive use also denies the sovereignty of the legislatures itself to debate the necessity of the clause in the light of any possible overreaching judicial decisions. So to some extent, the very use of the preemptive clause is a violation of parliamentary sovereignty. The failure to have such democratic examination either inside or outside the legislature regarding the constitutional rights of 55,000 of the lowest paid workers in Ontario created a massive social response, which was done not only by the aggrieved workers, but many of the people who felt they were being unjustly treated. When some of those workers prepared to pay hefty fines and walk off the job, the government decided to offer repealing Bill 28 if the union called off the strike. Faced with such massive response from, and this is a term I want to use deliberately, from the sovereignty of the people, the Ford government rescinded the bill with the clause. So I'm saying that these three instances of the use of an autocratic use of the clause by the Ford government are basically an example of them misusing the whole concept of the sovereignty of the legislature to claim that it is part of their democratic right to do so. But sadly, this misuse of the concept of sovereignty of the parliament is now being picked up by Quebec Premier François Legault, who uses now the preemptive use primarily to cement his political priorities, such as, for example, through the secularism bill in Bill 21, then to justify the autocratic methods of promoting the French language in Bill 96, which, if you examine the actual contents of the bill, undermines not just those who are in the minority language rights, but the privacy rights of all Quebecers, the constitutional rights of many Quebecers, the equality rights of many Quebecers, through this use of the preemptive clause, with no real understanding and discussion of how it impacts on all Quebecers, not just the minority language communities. Now, sadly, the Quebec Court of Appeal has confirmed the virtually unrestricted use of the clause is settled law by the Supreme Court of Canada since the 1988 ruling in Ford versus Quebec. I'm suggesting that if this case does go to the Supreme Court of Canada, as it probably will, that unrestricted version of the use of the clause will be contested, if not by the present federal government, by at least several interveners, some of them who may be present here. Supporters of the clause, like Professor William Rousseau, one of the architects of Bill 21, has asserted that the use of the clause is about national identity and has been a victory for democracy in Quebec. In a paper presented at the University of Ottawa's 2024 Public Law Conference, he argued that there is a need to protect the national character of the state against judicial decisions. Comparing, frankly, incompatible situations in Quebec with, of all places, Israel, Professor Rousseau argued that in Quebec, the Act respecting the laicity of the state and Bill 96 aims to protect democracy in Quebec as expressed in the legislature, which protects the national character of the state against judicial decisions that promote supremacy of fundamental rights. In his paper, he argues that his support is actually confirmed by some of the decisions of the Israeli Supreme Court, ignoring the fact that one of the most important decisions was handed down by the legendary Justice Aaron Barak in the Bank Miserere case. And what he says there is in direct contradiction to everything that just Professor Rousseau has said. I just want to quote to you from this brilliant decision by Justice Barak. He says, "Indeed, true democracy cannot exist without limitations of the power of the democracy, so as to protect the values of the State of Israel as a Jewish and democratic state, and so as to protect the fundamental values of which human rights are primary." Then he goes on to conclude, "Democracy of the majority alone, unaccompanied by a democracy of values, is formal statistical democracy. True democracy limits the power of the majority in order to protect the values of society." And the report that Professor Rousseau has just handed down, where he wants now to completely insulate the entirety of Quebec laws against the Charter by coming up with some sort of crazy formulation, that essentially he only talks about how to exclude. No way does he talk about the dangers to the values of Quebec, as opposed to saying we just want to essentially exclude completely the entirety of Quebec laws by his report that's just handed down. I'd be happy to discuss that further. And I'll leave it at that, and hopefully that others can pick up on some of the things I've raised. Over to you, Marion.
Can people on Zoom hear me? I'm assuming yes, unless I hear different. Okay, I'll go. I think I'm going to stay in my chair. It's very comfy. So my topic is also Ontario. And the question that I'm trying to deal with today is Section 33 normalized or more taboo than ever? Now, Errol and I came up with this question much earlier in 2024, and I thought I had figured the answer, and then this month happened and the answer changed again. So I'm going to retell kind of the story that Errol just told, but more from the perspective of what happened and then how was it talked about. And I'll do it in the story of Ontario in 4 episodes, starting in 2018. So episode 1, in 2018 is when Ontario first starts to flirt with using the Notwithstanding Clause in the context of the City of Toronto changes, and Errol described them in detail. So interesting here, the changes in the size of the City Council were challenged at Superior Court. A Superior Court judge found that they were unconstitutional. And Ontario did 2 things. 1, they appealed the decision, and 2, they tabled legislation with the Notwithstanding Clause. Now, because this was a very fast-moving case, the appeal was decided, and Ontario won the appeal, so they didn't actually pass the legislation that had the Notwithstanding Clause in it. So what was the public reaction around this time? So I'm a lawyer, not an expert in public opinion, but I do remember in 2018, there was a lot of discussion about what was happening in the media. It was a big deal. For example, there was a group of 80 law professors that signed an open letter denouncing the use of Section 33. And that's pretty unusual to get that kind of mobilization from lawyers and law professors around an issue like this. But interestingly, I'm not sure that the public would have had much of an understanding of what the Notwithstanding Clause was, because if you think about it, it had never before been used in Ontario. So most people had never heard of it being used in their lifetime, unless they were around in the 80s and were following kind of national politics. But nonetheless, it did generate a lot of discussion at the time. So episode 2, which would be use number 2 or number 1 if you don't count the City of Toronto use as a use to 2021. Errol talked about this one too. So this is the election spending legislation. So this was a law that added more restrictions to what third parties could spend in the pre-election period, which was challenged under, again, freedom of expression and was found to be unconstitutional at the Superior Court level. Now, what was Ontario's reaction this time? Instead of appealing, so forget about the appeal, let's go just straight to the Notwithstanding Clause. So that's what they did. They chose not to appeal, but rather reenact the law right away with Section 33 in it. Now, what was the public reaction at the time? I don't remember this being discussed at all. It was certainly less of a big deal than the 2018 City of Toronto invocation. Some people probably spoke up to denounce it, but it really didn't have the same play as it had at the last time. And I think that is part of a trend. The more it is used, the less of a big deal it is each time, generally. And Professor Mendez talked about how that litigation played out, and we're still waiting for the decision of the Supreme Court. But I doubt the Supreme Court will talk about Section 33 in its decision. It's going to wait for the big ones, I think. Now, Episode 3, 2022. So this is when Ontario tries to use it with the dispute with education support workers. I remember this one because I had a kid in school at the time. So the question of, will there be school on Monday was on the mind. So the education support workers were about to go on strike, and the government preemptively enacted a back to work bill, preemptively invoking Section 33 to prevent the strike and shield the law from any challenges based on freedom of association. And it was called the Keeping Students in Class Act. We have to understand, it was late in the pandemic. Schools had been opening and closing periodically, and anyone with kids in schools would have living this. And so the narrative by the Minister of Education at the time was like, we can't let the schools close again. It's really important. So that was the justification at the time. And I do have a very specific memory of this because this was the Monday of the Bill 21 hearing in Montreal, and I had to travel to Montreal for that hearing. And I didn't know whether my kid was going to be in school or not that day. But I also remember on the first day of the Bill 21 hearing, one of the lawyers opposing Bill 21 got up and told the Court of Appeal, look what's happening in Ontario. It's spreading. But by the end of the hearing, by the end of that week, the whole thing was resolved in Ontario because the public outcry was so strong that the government ultimately withdrew or repealed the legislation. Now, this is an important sort of moment, but I think it's really important also to note that this was a labor dispute. So labor was, by definition, organized. They were all ready. They had their networks. They were ready to respond to anything. And so it was sort of a plug and play in terms of public opposition and public outcry. It's a very different situation when you're thinking about, well, if it's targeting a particular minority or a group that's more vulnerable that doesn't have that kind of mobilization already. But in any event, the idea of public outcry, being able to push back on Section 33, this is probably a great example of that. And so this is the example of the democratic function of Section 33. Now, I wish that was the end of the story. Ontario hasn't actually invoked Section 33 after that episode. But as I said, 2024 marches on, and there's more to say now. There's Episode 4. So just a month ago, the Premier of Ontario suggested that Section 33 should be used to help clear homeless encampments. And he asked the mayors to ask him to invoke the clause. And in fact, 13 mayors or 15, I'm not sure, wrote to the Premier and asked him to do that. So this was an eyebrow raiser when I first heard about this. Like, how can Section 33 fix homelessness? But there is a backstory to this. So there was a decision by a Superior Court, I think in Waterloo, which found that it's a violation of Section 7 of the Charter to evict homeless encampments if there are not enough shelter spaces available. So they said that's a violation of life, liberty, and security of the person. So yes, this is we're talking about a preemptive use here, but there's a judicial kind of pedigree to it. But anyway, the logic here is very difficult for me to grasp because it means you would only really need Section 33 if a city wanted to destroy a homeless encampment and they didn't have any other shelter spaces. If they did, the judicial decision wouldn't get in the way of that. But actually, the letter from the mayors that was sent to the premier asked the province for a lot of different things, a lot of provincial support, legal and otherwise. And Section 33 is one of those things, but it wasn't the only one. But it's the only one anyone is talking about. And I think it's totally distracted from the very complex policy issues at play when we talk about an issue like homeless encampments. And Diana Chan McNally, who is a frontline worker supporting homeless people, wrote this in the Toronto Star. If we fully remove the right to life for one group of people, who's next? What does the Charter mean if the elected leaders of the day can blithely abuse the Notwithstanding Clause, which was meant to be used in the rarest circumstances to take away the very rights the Charter protects? I really can't say it any better than that. Now, Ontario hasn't actually invoked any legislation like this yet. However, it's kind of an open issue right now. And there's actually been a lot of discussion about it, counter letters from other mayors and city councillors saying, yes, help us deal with homeless encampments, but no, don't use Section 33. Civil society has organized, there's been open letters, petitions, all kinds of things. So this story is right now kind of to be continued. And so why do we talk about these little skirmishes if nothing's actually coming of them? Well, the very week after Doug Ford floated this idea, the Premier of Quebec spontaneously suggested that Section 33 could help with Quebec's doctor shortage by forcing doctors to remain in the public health care system in the province. Coincidence in timing? I just can't imagine. I think these things do have knock-on effects. Ontario and Quebec often dovetail on the timing of their use of Section 33, although most folks that I talk to in Ontario and Quebec don't realize that it's happening because we're so siloed in our own context. But I think those two premiers do watch each other quite closely. So to conclude, is Section 33 normalized or more taboo than ever? Up until a month ago, I would have said it was taboo. I think Doug Ford may have learned a lesson in 2022, but now I'd say we've entered a new kind of chapter or episode where, as I said at the beginning, it's gone from a taboo to maybe a reflex, maybe a gamble, maybe just a distraction. Maybe it's a signal that, okay, I'm going to take this really seriously. I'm going to invoke Section 33 like it's like a magic. But I also think the Ontario case is really interesting right now because like this week, this month, we're in a window where civil society is doing its job and talking about whether it's appropriate to invoke Section 33 here. It's being actively debated and people can, I encourage anyone who hasn't yet done so to get involved in that debate. And I also wonder, I just want to throw an idea out that Errol and I were throwing around earlier this morning, but we're all very siloed in our own context, but is there enough momentum now to coalesce around joining forces, all the different groups that are being affected and are pushing back in their own places? Is it time for us all to get connected and start talking to each other much more strategically? So I'll leave it there.
Thank you very much, Marion. So the next speaker is Senator Harder.
Thank you very much, Errol, and thank you to the organizers. I come to this conversation as the least equipped. I am not a lawyer, and I'm not a member of an elected chamber. I am a member of an appointed chamber. But I come to this issue with a deep worry about the normalization and the trivialization of Section 33. You've made the case for my point of view in the course of the last few hours of references to different attempts, both successful and unsuccessful, But we've come a long way from the good chap theory of government of Peter Lougheed. We are experiencing, regrettably, in my view, a disregard for institutions and a populism of politics that provide the conditions for the trivialization and the abuse of Section 33. And that the hopes that Peter Lougheed expressed over the years of what the obligations of elected representatives are in the course of Section 33 being invoked are absent. I was particularly frustrated with not only the decisions with respect to its use at the province level, but last spring, the leader of the opposition federally expressed the view that he would utilize the Notwithstanding Clause in the face of his law and order campaign. By definition, then, that is the most, that's an egregious attack on the most vulnerable. It will be very difficult. And I was concerned that there was no, I thought, appropriate reaction at the political class, in the media and amongst civil society, partly because of the vulgarization of politics, but also the attack or the intended group that he was speaking to are those that are most difficult to defend in public, the incarcerated, or the, in this case, it would be to ensure longer term sentencing. And I thought I should use the safety of the Senate to try to make a point about this. So I tabled a motion in May that said the Senate should express the view that it should not adopt any bill that contains a declaration pursuant to Section 33 of the Canadian Charter of Rights and Freedoms, commonly known as the Notwithstanding Clause, hoping that that would shake some attention. And the good news, colleagues, is that there are 3 other senators here today. And I spoke to this, this motion earlier this fall. And in the course of making the argument for my motion, I reviewed some of the cases that you've referenced today. But I wanted today to focus more specifically on why did I do this? Why the Senate? Well, arguably, I would have wished that this would have been a House of Commons initiative. But the issue at hand is either so far down the priority list of political conversation, or so difficult for politicians to get a handle around because of the intended point of the use of the Notwithstanding Clause, that you needed the safety of a Senate appointment. And I took comfort from the Supreme Court reference, and I want to read you paragraph 16 of that reference, which speaks to the Senate's constitutional representation of people largely underrepresented in the House of Commons, such as Aboriginal, linguistic, ethnic, gender, and religious minorities. And at paragraph 57, the court continues, "It is clear that the intention was to make the Senate a thoroughly independent body which could canvass dispassionately the measures of the House of Commons." It continues saying, "The framers sought to endow the Senate with independence from the electoral process to which members of the House of Commons were subject in order to remove senators from a partisan political arena that required unremitting consideration of short-term political objectives." So there is an obligation, I would argue, for the Senate to take on this issue of the Notwithstanding Clause. It is also important to note in this conversation that it has never been used by any federal administration. So this is the first time it's been referenced, albeit by a leader of the opposition, but I would point to the poll standards, which would suggest that may not be his long-term ambition. Even his idol, Prime Minister Harper, did not use the notwithstanding clause. Now, his device was interesting because I'm now making a parenthesis. He used private members' business to achieve what he could not have achieved with government legislation, because the government legislation would have definitely had the contestation of the Department of Justice. So the famous case is 377, which was anti-scab legislation, which ultimately created a division in the Conservative caucus in the Senate, led to departures and all of this. My point is, even Mr. Harper would not have used the notwithstanding clause in the face of his frustration on labor law. So how should the Senate act in a hypothetical use of the notwithstanding clause by the Government of Canada? And I outlined what I would view as what guidance should the Senate take on itself for how it would utilize its role in a legislative process. Well, the first thing is, if it is preemptive, it should be absolutely fought. But if it is post-judicial, maybe there are other areas in which the Senate should ensure appropriate consideration. So preemptive is the number one. Second is, did it come to the Senate with multi-party support or the Lougheed principle of 60%? If not, that's worthy of reflection. Third, did the Minister of Justice table, as is now required, a charter statement? A confession of guilt, I guess, is what I'm looking for. Third, did the government in the House of Commons use time allocation? This is a delightful tool, often used by majority parliaments to not only expedite the consideration of legislation, but to ensure that there is very little time for public reaction or understanding, for that matter, of the legislation to be developed. In the 41st Parliament, which was the only majority parliament of Prime Minister Harper, he used time allocation 24 times, including using time allocation on the day it arrived in the Senate. So the Senate has been, in my view, abused in its responsibility for what we call sober second thought, although, as I said to a colleague the other day, I think we're drunk with sober second thought these days. So is time allocation used? And has there been a full public debate? In other words, to use Peter Russell's language, has the active citizen involvement taken place? Those are the issues that I think should guide how and to what extent the Senate exercised its responsibility. And I'm delighted to say that a number of my colleagues have joined in this motion debate. But here's where I think we need to go, and I'll end with that. In the absence of the political class taking this up as an issue, by that I mean political parties or the House of Commons members of Parliament, I think it's time for the Senate to have introduce a piece of legislation that would concrete form provide the framework for the guidelines I've just outlined. In other words, it won't pass, right? I mean, but it will help nurture the public conversation and maybe inspire a government, if not right away, at some point to say, here is how the federal government's potential use of Section 33 would be guided. And I would encourage anybody to add to my list of let's say, guardrails or guidelines. And maybe the next phase of this inquiry is to get a bill introduced that could be then studied by a parliamentary committee and hear from the public more broadly. I don't know what else to do other than hold conferences of the persuaded. So I would encourage some ventilation of these issues by the sponsoring organizations of today's event. Thank you.
I think there's people writing down in great detail what some of your suggestions, which we will be examining in closer detail. The one other thing which I'm hoping you will consider is actually getting our provincial legislatures to do the same thing, perhaps, and that would be wonderful too.
What they really need to do is, of course, create an upper chamber.
Exactly. Okay, and with that perfect political response, over to Althea for giving the media's perspective, and it's more than perspective. Althea is one of the most amazing and talented journalists we have on public issues. Althea, over to you.
Can I use this opportunity to just ask you questions? Because you guys are the experts. I'm
Sure.
just an interested party. So I will say that I too thought Pierre Poilievre's comments, I think it was at the police conference, were shocking. And I was watching on CPAC, I wasn't in the room. I thought, well, this should be a front page story. I don't believe it was a front page story, not in our pay, not in anybody's paper.
No.
And so I really agree with what Marion has talked about in terms of it is no longer taboo. It's not even really news anymore. And I'm not convinced that if the unions hadn't suggested that maybe there would be a general strike in the province, that the government would have reversed course. Because I don't think that they wanted to have a Manitoba repeat 100 years later. Harold, you talked about what the limit would look like. What would the limit look like in your view? Because you stopped short of telling us what you think it should be.
Is this working? No, it's fine. It's fine. No, it's the reason why I specifically asked the question about Peter Lougheed, and then in my presentation, I focused on the preemptive clause. There is lots of evidence to show that that was the intention of not just Pierre Elliott Trudeau, but most of the premiers, even Blakeney. And I'd be interested to see what the senator from Saskatchewan, I think even he would not have gone along with this idea that the preemptive clause should not be used. So that's number one. That should definitely be the biggest strike against it. Number two is to get people more aware that this whole idea of using the clause as a right, the sovereignty of the legislature, is bunk. Essentially, it is not the sovereignty of the legislature. It's the sovereignty of usually one person or maybe a group of people who feel they can impose their perspective on the rest of people in that community, in the province, or even in general in Canada. So essentially, the focus on the preemptive clause, and basically, as Peter has suggested, finding ways to make sure that there is at least some minimal element of public discussion of what is being proposed. Now, that only happens after a judicial decision. So what can you do in the absence of a judicial decision to get people to basically discuss the impact? You know, when you look at what happened down south, yes, he won the election, but you know, the actual result was quite close. And people really did believe that democracy was at risk down south. We have to start people thinking about now, that is actually as much of a danger here as it was in the US. Now, we may never win, but at least there was at least a start to making having discussion that our democracy, our rule of law is very fragile, and we have to start thinking along those lines. And that's where Marion is focused on in terms of trying to get that public reaction to this. And, you know, we are actually going to ask you to actually have a follow-up with us and other media people to find out, you know, if Joe Rogan could reach 1 million people with one podcast, my God, Canada has to come up with something which is as perhaps not as important, as we'll never be able to do that, but how do we integrate different forms of media to get the message across that these are critical issues that the public should concern about? Is that an answer?
I think that's like a whole other conference on like the state of the media and where traditional media has gone. You're lifting your microphone, so yes.
Well, I just wanted to add to what Errol was saying. I think that the framing of the judicial supremacy or parliamentary supremacy is a deliberate misinterpretation of what we're talking about. I'm talking about constitutional supremacy. And that means certain rights and obligations on both sides to adhere to the process. And I think that would be better understood by the public. We're letting the issue be defined by the worst of its advocates.
Why did you say you think the bill would not pass? Just because of the timing or because of the lack of support in the upper chamber?
It would be a private member's bill and therefore easy to derail, just procedurally. But I would prefer if it were a government bill in the House of Commons, and the Senate would then reflect on that in its role. But in the absence of a willingness by anybody in the House of Commons side, maybe we should in the Senate provoke that conversation so that there can be hearings and a broader discussion of this. And maybe there would be some interest by the elected political class to take that up in a government bill.
So I feel like you started the conversation by bringing forward the motion. There is no interest in the House side because of political consideration. On the government side, because of votes in Quebec. The Bloc Québécois obviously will never support this. The Conservatives ideologically don't support this either. And the NDP seems to waffle. So aside from Elizabeth May, I'm not sure who would want to have this conversation in the House of Commons. But on the Senate side, not only would, you can move on to a bill and get people like me to start talking about it.
True, and that's why I would do it. So I do think.
Do it, Peter.
Well, let's start with the inquiry and then the next step. But just for the record, Mr. Mulroney as Prime Minister had some very specific and harsh words for the Notwithstanding Clause and its value in our Constitution. Mr. Chrétien spoke eloquently about his view as to what the origins of the clause were and what was an appropriate use. We've had Mr. Martin as Prime Minister saying that were he to be elected or re-elected, he would introduce federal legislation. Now he lost the election. So there have been times where there has been at least some voices at the federal level that have been willing to take this on. They're just absent now.
Do you feel that if you had the legislative time in the upper chamber to debate this, that it would pass, that a majority of the independent senators at the moment would support?
Absolutely. That would be my view, and the tone of the debate in the chamber on my motion would reflect that.
Marion, I see that you've been writing and jotting down notes. Somebody mentioned I think it was you who talked about Stephen Harper. I think if Stephen Harper was elected now, he would not hesitate to invoke the Notwithstanding Clause preemptively. I think the only reason he didn't do it was because the norm hadn't been broken, and now it has, and you can't put the toothpaste back in the tube. And the discussion that I feel like we're kind of talking around is that, and your example and the example of the homeless encampment speaks to it. We're not talking about the norms that are at stake, the values, to use your word, Errol, that are at stake. We're not talking about the thing that's most important than you feeling slightly unsafe because there are homeless people at the park and you want to take your kids there. And that seems to be where the politicians have taken the discussion. And I don't want to take anything away from what you wanted to say, but I'm wondering if maybe you can comment on that too.
So I have a thought, and I'm also going to use your question to segue into a question from Zoom.
I forgot about
because I'm supposed to. I'll segue to what there's questions in other cities too, but I'll make it smooth. So as you were speaking out, I remembered something that Karine Miller was talking to, and others have talked about it, but that oftentimes we're seeing these things directed at people who are the most vulnerable. And I think that there's a very, I don't know about deliberate, but there's a nefarious effect of that because it's easiest, or it's hardest to defend those types of uses or those groups, right? And I think we've seen it's not every time, not every use of Section 33, but often. And that has a nefarious nefarious effect on the value we place on rights themselves, right? The whole idea of fundamental rights. And Karine Miller this morning did a really good job making the case for why maybe this doesn't affect me personally. I don't care so much about this particular right for this particular person, but wow, I would care, if this happened. And that is just nowhere, I think, in the public discussion right now. And I think it can be, and it has been in the 20th century, a very powerful way to bring people back together, speak the same language, as it were, or have some respect across differences. And I think maybe we can find some space for that again, I hope, to bring that back in. Now, to segue to a question that's related to your question, Althea. Marion, okay, I'm talking about myself in the third person. Marion talks about the clause being perhaps a distraction now. Is it not more likely that the use of the clause, or rather the threat of the use of the clause, is more so the use of a club by leaders who have found purchase in advancing their bully personalities? That question is from Suzanne B. Does anyone want to take that on?
I think the notwithstanding clause is going to be used in a version of wedge politics 2.0. It's being used for political leaders to portray themselves as defending some people's rights versus other people's rights, but not in that language. So I think that it's even more dangerous than we're even really talking about, because I think it's going to become more and more normalized. And nobody is going to want to put political skin in defending the other part of that equation.
And it will be used with language that shows I'm with the people against the elites. And the elites are protected constitutionally by definition.
Or like they're out of touch because they care about bail reform.
Yeah, it's hard to believe the incarcerated become the new elites, but
Can I give one small little hope of optimism? And it's the thing I learned most about from all your presentations, which I didn't know about, was the one presented by Vincent. So I hope that Vincent is still there in Montreal, or if he isn't, can pass it on to him. Didn't know that there was this survey done in Quebec that in terms of the reaction of people, once you went back just from the survey, that what are you in favor of Bill 21 to present to stop the wearing of religious headgear? The majority of people, I think he said about 69%. But when he basically followed up with a survey and said, can you just tell me how you feel about the fact that it's impacting on certain people? I was stunned. I didn't know about this, that it was a 40-40 split, that there were 40% of people who said it's wrong against another 40 who said it was right. That's hope, because the general perception is that you can't argue about Bill 21 in Quebec because everyone is in agreement with it. That's not true, based on this survey that just one person did. Why don't we go forward? And I bet you any money that if we delve further and further into that, the people who are actually saying, well, initially I agreed with it, but now based on what the values were involved with that, how can I actually support this? You delve further into it, maybe that portion will grow. I'm dying to get the reaction of somebody who probably knows what I'm talking about. My boss, Jacques Frémont, who was former head of the Quebec Human Rights Commission. Am I wrong in that, Jacques?
Even my understanding, even the Quebec Liberal Party would not take position, would not vote for that. So it's populism at its worst. There are very few voices like yours, like ours, to defend that it's basically a matter of rights. And the dominant discourse in Quebec, and it's food for thought, is majority have rights too, and we can enjoy the rights given by the charter. So actually my reading of the political life in Quebec is now, apart from freedom of expression, I mean, the premier is making very light. I mean, rights do not count in regard of the majority of the will of the majority of people. So there's lots of manipulation. I'm not sure at all that the same poll, which was referred to, that it would be 40-40 now. And the Trump effect in Canada also plays, I mean, the courts are not usually popular these days.
I'm actually not sure about that. Like, if you think back on the headscarf issue, you remember a story, I don't remember if it was 2 years ago or 1 year ago or 3 years ago, there was a teacher in Chelsea that had been let go because she was swooped up in Bill 21. And there was a huge outcry from the community. Okay, granted, lots of Anglophones in Chelsea, and it's a bit more of a progressive, closer to Ontario community. But when you have stories where you recognize that that is a human that is affected, and you don't talk about it in terms of this big policy issue and esoteric terms, and you really narrow down to the human being affected by the policy, whether it was that teacher or that homeless person that has no shelter space and has been living on the streets for 8 years and has a name and has a family and has a story, people start identifying with those people.
Despite my boss killing my small area of optimism, I still want to agree with you because, you know, one of the benefits of being a professor at the University of Ottawa, we have Quebec students from different parts of Quebec. And I'm always really surprised at how the younger Quebecers basically are saying exactly what you said. So maybe there's hope, but it has to grow. I don't know how you make it grow. We have been in touch with many of the younger Quebecers who actually don't agree with Bill 21, and they are trying to find ways to fight it. But it's tough. So, you know, yes, I know the optimism is very small, but I think it can grow. If you focus not so much on rights, maybe the whole focus should be on values. If you are willing to say the values of the most vulnerable, to quote Senator Harder's view, the most vulnerable people in our society, you have no right, you have no basis for caring about what happens to them. That's basically saying you have no values in terms of your role as a citizen for the most vulnerable in society. So maybe that's too much of a small optimistic hope, but I'm clinging on to it.
I'm going to exercise my role as panel question answer moderator to take us to Montreal. I think there are some questions in Montreal. I know the time is ticking, so could I ask Montreal, pourriez-vous demander vos questions dans un groupe, peut-être une ou deux ou trois ou n'importe quel, et là, après, on va les répondre aux questions ensemble. Merci.
Oui, je pense que je suis la personne qui demande en série toutes les questions. Well,
Vas-y, Céleste.
I'll ask in English. So I'll just say it as, okay, they're asking for the video to be turned on.
No, we see you. Oh, we did. We will soon see you.
I'll say, so.
Oh, we see you. On vous voit.
Vous m'entendez?
Oui.
Parfait. So my mentor and one of my friends, Barbara Finley, this amazing queer lawyer who's been going for so long, we were chatting about the Notwithstanding Clause earlier this year, and she's telling me about how, you know, it's a 5-alarm fire that nobody cares about. It's something which, it's like the biggest constitutional crisis in this country that no one's giving a damn about. And I'm seeing, you know, how people who are more directly affected by the Notwithstanding Clause than anyone else, they happen to be the folks who care the most about it. And folks, you know, debating right now whether what is happening, for example, to the trans media in Alberta and Saskatchewan can be construed as genocide. And that's a very strong word, you know? So my question for all of you is, how do we make the general population, please pardon my language, give a damn about human rights for once? It seems that we no longer care about human rights. It seems that we live in a world in which the other is readily being thrown under the bus because they are the other. Where people who are, you know, people are being construed as monsters. They're being depicted as such. Just look at any depiction of trans women in the National Post in the last 5 years and you know. So what can we do to humanize the other? What can we do to make sure that people People care about each other's human rights. As the famous saying goes, first they came for the socialists. I did not speak up because I'm not a socialist. Then they came for the Jews, etc., etc., etc. How can we avoid that from happening again? Because right now it seems pretty damn scary, and it seems like we are getting pretty close to that actually happening.
And that that was very moving for me, and I think that's a theme that's come out today. I think what's happened, I don't know why or how, but in the past decade or 2 or 3, I don't know, rights discourse has become about me, my community and me and my specificity. And I think if we want to reverse the course of the erosion that we're seeing and the fragmentation that we're seeing, I think we need to make rights about us again. And so I think that's where we need to be thinking and going. And also we need to be joining up forces with everyone who's in their own little silo, having the same kind of, there's a lot of, I talk to a lot of people who are in the same headspace as you are. And I think we just need to join up together.
Let me get in on this as well. I think that's one of the lessons, even from the American election campaign, is the DEI language has been exclusive, not inclusive. And we have to find ways of attaching what we're talking about to concepts that I think are still very strong in the heart of Canadians. I do think the Charter, Canadians are fundamentally attached to the Charter. We have senators on being sworn in rather than on a book of faith will come with the Charter. And the Charter is language that has a resonance in Canadians, but we don't attach this conversation to the Charter. And I think we should. That the issues around sort of the constitutionalization of rights needs to be attached to real individual experiences. And Althea's comments about speaking about the individuals is really important as long as it's connected to the community.
Take another stab at it also. And it comes from many of the travels I've done around the world, being the head of the Human Rights Center at the University of Ottawa and having projects around the world. I'm amazed when I've gone to countries like China, Thailand, parts of Africa, where the notion of human rights is foreign to them because they can basically able to survive for poverty or because of oppressive dictatorships. But the one thing they all understand is the concept of human dignity. Everywhere I go, when I ask people, what is it that you care most about in terms of how the government is treating you or what others are treating you, they say dignity. Dignity is what we want. Somehow we have to have that sort of approach again, including, well, as you say, Senator, which makes us less exclusive in terms of having the traditional lingo of inclusion, diversity, etc. We have to come up with that. One of the most popular things I've ever done when I was the director was I wanted to celebrate the 50th anniversary of the Universal Declaration of Human Rights. So I basically said, I'm not going to have any lawyers go to this event at the National Arts Center. I want to have artists, I want to have poets, I want to have musicians. It was the whole place was filled. The entire of the National Arts Center was filled. Maybe we should start thinking along those lines again as to how do we bring that concept of human dignity back into the discussion.
But just one two-handed comment. That dignity needs to be afforded the people who disagree with us. In other words, if the convoy taught me anything, it's we need to recognize that even those who disagree with us are part of the dignity conversation. Brent.
Well, not so much a
Ottawa?
question, but it's Brent Cotter from Ottawa. I just wanted to respond. Firstly, I think the president is right in his discouraging observation, more so than Professor Mendes' hopefulness. But in response to the question that was posed about transgender people, let me offer at least a small vein of hope based on what I would call evidence. In the New Brunswick election, in a significant way, the Premier of New Brunswick ran on a platform that was anti-trans kids and the like, and got his ass kicked. In Saskatchewan, the Premier even more so ran on a anti-trans kids agenda, much more explicit even. And while the Premier of Saskatchewan was re-elected, in the two major cities of the province, where I think there's a collection of, I don't want to be too insulting here, but better educated, more progressive communities, there are 26 seats in the province in that election. The government lost 25 of them. And almost entirely, I think, driven not because he had bad economic policies or the government was running poorly, because he chose this kind of thing to advance as a political priority. And the people in those parts of the province let him know that that was not acceptable. It's not an overwhelming piece of hope in light of the message, but it's at least, I think, evidence, Errol. Thanks.
Thank you very much, Senator Cotter. And I think we're going to go to Edmonton next for any questions from that room.
Can everyone hear us in Ottawa? Okay. So first of all, thank you for that panel. I thought it was fantastic. And thank you for the post-panel conversation as well. I'll preface this, first of all, by saying I'm Northern Irish. So I belligerently mispronounce the word power. So whenever I say par, I mean power. I always have to say that in Canada. So my question basically is, if part of our aim is to, or one of our many hopes here is to bring courts a little bit more into the public conversation around given invocations of Section 33, why are we not talking more about the reference par / reference power? I mean, it seems like there's so many advantages there. One would be that you avoid the need to make legal arguments that circumvent the Notwithstanding Clause. You can just pose reference questions about charter violations as if the clause hasn't been invoked. Two is that if you use it at the federal level, and if we put pressure on the federal government to use the reference power, we push the issue directly to the Supreme Court, so to the nation's highest court, and get its opinion as part of the public dialogue around the given invocation. And then three, and this links in with point two, you're asking the court by definition to contribute to the public debate in this really limited advisory capacity. So you're not asking it to intervene decisively and shut down the debate. You're just asking it to make a contribution around the extent of the rights violation and the possibility of justification. So why don't we talk? I'm partly crediting this, or I should credit it to Charisma Mathen, who's written a really interesting paper partly on that issue. Why don't we talk about that more?
I have thoughts. Does anyone have thoughts? I was talking about it. Interestingly, I don't know if anyone's noticed, but the federal government hasn't sent a reference to the Supreme Court since 2014. No liberal, the current liberal government.
For the Senate, I should add.
Exactly, over the Senate, and also about the appointment of Justice Nadon, and that was the Harper government. The current liberal federal government has never exercised the reference power. My sense is that the reason why they didn't do it on Section 33, there could be many, but the most obvious one is that Bill 21 was making its way up with a great evidentiary record and a great set of legal arguments, and sending a reference would kind of circumvent that process, which could be damaging in terms of the conversation that needs to happen in Quebec around this. But there could be other reasons, and that rationale could now have changed because of the more and more use of Section 33. So I'd be interested to hear what others think.
I have a curious response, Richard. I think there has been a reference dealing with this particular this clause, but in an indirect way, and I think it's the Quebec secession reference case, because the reason why I emphasize so much the dissent in the Ford decision on the Toronto elections, and the fact that we managed to get a strong dissent, it became clear that there are a substantial part of our Supreme Court of Canada is willing to use the unwritten principles, ultimately to put a curb on the autocratic use. And certainly, I, for one, am going to be strongly looking at that possibility, when Bill 21 gets up to the Supreme Court of Canada, because I think that there is sufficient there in the dissent which possibly allows for much further detailed examination on how and what conditions the principles of democracy, the rule of law, and the protection of minorities can be used to at least curtail the most autocratic use, and potentially could, I think, be possibly used if the secession case ever gets to the Supreme Court of Canada. When you have kids who are potentially in danger of committing suicide because of what the government wants to do now with pronouns, surely there should be some sense to say you can only go so far. You cannot go as far as actually endangering kids committing suicide just because you want to take away their right to have pronouns. So I think there is possibilities there, but it's going to require a lot of detailed examination of how far you can push that very strong dissent, because there have been many cases where dissents have turned into majorities over time.
I think it's the politics of the moment that progressives would rather have the fingerprints of the courts on corrections than take the risk of stating a political position that for which you may pay a cost.
I think maybe I share the same opinion, but in a different way. I don't think that if you're in government, you would ask the court to weigh in on something unless you know what they're going to say. And if you don't know, it's a risk you may not be worth taking, which is all the more reason why I think you should table your bill. So the court knows at least what one chamber of the legislature believes.
Would at least one journalist cover it?
I would absolutely cover it. You know, I would. But I think that has been of big concern. And on the Nadon stuff, I think they had no choice. So that's not like they really wanted to.
Are there any more questions from Edmonton?
Can I ask you a question?
Go ahead. And then there's one more in the Zoom as well. And then we probably should close. Well, Errol will do some closing remarks. Okay, so that's what we'll do.
What if Bill 21 is not decided the way you expect it to?
I expect that it will be decided not the way I hope it to be decided. I think that makes sense. I'm expecting to be disappointed, I think is what I'm saying. That's just my personal, I don't have a crystal ball and I'm usually horrible at predicting the future, but I think there's been far, far too much stake and hope put into this one decision of the Supreme Court that's coming. And I think a lot of people have like unrealistic expectations of what that can do or what it can't do. I've kind of turned my focus more towards civil society and the democratic process and things like that, reviving rights as a value and things like that, because I don't think one judicial decision is going to stem the tide of all the things we're talking about here.
But like, do we expect that they will say that the preemptive use is okay? Is that what you're saying?
Yeah. I think yes. Sadly, I would agree with Marion that the chances are very high that they would disappoint those of us who want to find ways to limit the use of Section 93. But I place a lot of emphasis on potential arguments coming out of dissent. So even if those who want to have it overturned completely have a dissent, that's something, because society can build on dissents. And well, actually, I have to tell you what I said to my class. The last class I said, when I tested them and asked them, how long has it taken for Canada to have an effective criminal justice system? And most of them said, well, 150 years. I said, no, 1,000 years. It started with the Magna Carta. And so one of the things we have to do is to think about, yes, even if we're disappointed in the short term, what we can do as individuals, as senators, as academics, as civil society, what we can do to try and push it a little bit further, step by step, knowing that sometime in the future, we'll get a much better result. Am I too optimistic again?
Long arc of history.
The question online, unfortunately, my laptop battery just died, but I wonder if Slava Balan can read out the question for us.
Actually, I've got two questions. So one is this. I'm a second-year law student from Dalhousie, currently writing a research paper on the effect of the increased use of the Notwithstanding Clause on Canada's international human rights obligations through the 7 major UN treaties which we have ratified. In my research, I have noted that there has been an alarming increase in international human rights law violations through the use of the Notwithstanding Clause in recent years. Do you see a world where the Supreme Court of Canada uses the international human rights law to inform our interpretation of Section 33 and constrain its use through these instruments?
The expert on this is Stefan Bolak, who's actually writing on this. And he is convinced that ultimately, again, it's that slow march. I like the use of the phrase, the long arc of history. But keep in mind that ultimately it does bend towards justice. And I think that if you can start putting together these arguments bit by bit by bit, every single argument helps. And suddenly there are now jurisprudence which not only in Canada, but internationally, where the international courts are trying to limit the ability to use what's called the derogation power in different scenarios. So ultimately, there should be more emphasis on that. The expert on this is Stefan Bolak from University of Montreal, and he is writing on this. In fact, he's writing a whole chapter for the next edition of the Charter of Rights book, which I'm editing, and Marion is also presenting a chapter on Section 33.
One more question from Zoom is this. Apart from Section 33 of the Charter, what specific provincial powers are provinces like Quebec relying on legally to pass legislation or policy or attempt to invoke the Notwithstanding Clause to override constitutionally protected rights? The public's interest argument was not successful in the Saskatchewan King's Bench case of students' use of pronouns. It seems to me to be an abuse of power and bring the justice system into disrepute for any government to use rules of civil proceeding in this way. I can reread once more. No, okay.
I'm afraid it will be another depressing answer. The provinces are increasingly using it. So the questioner mentioned Saskatchewan. Ontario has done it. Apparently, this latest attempt by Professor Rousseau is going to try and insulate the entirety of Quebec from the Charter, according to his report. And the latest I've heard, which is incredible, now Alberta is thinking of expanding it to fighting against any form of climate change proposals from the federal government by making it illegal for greenhouse gas producers to send any information about their emissions to the federal government, which is unbelievable, given the fact that they can expand the Notwithstanding Clause to areas which it never was intended at all. So it's getting more and more depressing. So ultimately, as Marion said, it's time, unless we can stop it by a social movement, it's only going to increase in matter. And that's why I think ultimately, perhaps we should start thinking more and more about what are the potential areas we can start what I call the beginning of a movement initiating idea. And I think Senator Harder has just proposed one. So it makes me feel as if we've actually got one possible small hope of something starting in a larger vein. And I think that's the end, right?
Yes, I was going to invite the panelists if they have any final remarks, and then it'll be back over to Errol to finish us off today.
Do you want to start? Yeah.
I thought I put it on. I just want you to know that when I do television, they mic me up. I don't do it myself. I'm depressed from the end of this panel. I hear what you're saying about the public mood and sort of the rallying of public pressure to say that this is something that we care about. The unifying message, I think, is really key that you both talked about. And I do think that there is a thirst among people to be part of something that is greater than themselves. The problem I find is that the financial and political imperatives are to put us into boxes. And that is how they make money, and that is how they get political support. And I think that perhaps at some point there will be a leader that emerges that has a more unifying message, but we don't have that at the moment. And so it will take somebody that's outside of the purview I look at, which is the House of Commons, to do that. So yeah, I mean, I don't know, Senator Harder, if you're the one, but we will do a rally for you and your in defense of the Constitution and try to drug up support if you want.
I guess I'm optimistic because civil society can be engaged. And that is where I would start. It will not be amongst the political classes, but it is a different approach to civil society where it's what we hold in common, not what we have in narrowly defined areas. And if I can just put one green shoot, the 13 mayors, some of them were roundly criticized in their council because they signed on without any council discussion. So civil society lives in small town Ontario.
Thank you, Senator
I
Harder.
still find it shocking that that many signed on.
I'll give my final words. Althea, I understand why you're depressed. When I talk to people, I often put them into this mood. I feel fired up. I feel encouraged by some of the new ideas that have come today. The fact that we had this conversation, I'm encouraged by that. And I have to say, I am sort of moving through life. I'm getting maybe a little older, a little wiser. And there's an expression I remember hearing as a child that I didn't really understand. And I think now all of us probably understand it a little bit better. And it's when you were talking about people being put into boxes and the political imperatives and all of that and what's happening south of the border, the only thing we have to fear is fear itself. Like that came from a different time. But I think we're all really understanding what it means now. If there's grand cycles, we can draw from those people in the past who have gained that wisdom. And, I'm always hopeful. And with that, I will turn the floor back over to Errol.
Well, I'm a realistic optimist, even though I'm beaten up all the time, but I remain an optimist. But here's where I think, and I'm hoping that Edmonton and Montreal can still hear us. I really think that our job is to come up with whatever we think can work in the short term. Hopefully that others can pick up on it, build on it, try and go further with it, and see where it happens in the longer term. And having Senator Harder come up with one idea, which maybe it'll flame out, but at least it's an attempt to try and do something to see what happens with it. And it goes back to the reason why I suggested that maybe we should try and focus a lot of our attention not only on rights but on values, because it's what I learned from traveling around the world. People do have the idea that underlying human rights is this concept of human dignity. And if you can convince them that their dignity is dependent on them respecting other people's dignity, that somehow you can work with them on an understanding, a human understanding, it takes a lot of work. And every single one of us has that task to do in our own little area. So, for all the people who spoke today in Edmonton, in Montreal, I know that they're all trying to do that in their own way, and thank you very much. And we will continue doing that too in ourselves at the University of Ottawa. And we thank everyone who's actually come in the audience, also virtually, and we encourage you to write to us and connect with us to tell us what ideas you have to try and move that that massive log of pessimism a little further away so that a little optimism can creep in underneath it. So with that, I'd like to thank everyone for coming, and we really appreciate all your help. Thank you very much, everyone.